Do what thou will be the whole piece of law.
He who represents himself in court has a fool for a client and an idiot for an attorney. Abraham Lincoln, probably. To set the stage for this trial that's about to unfold, I need to give you some of the background. This story centers around a man named Francis E Dec. He was a lawyer born in Nassau County, New York, in January of 1926. The rest of his family is not important to this part of the story, but what you need to know is that Francis would end up becoming a lawyer. You may ask how this is important, and that's because Francis is both the defendant and the lawyer in this case. At the time that I want to bring you to, it's 1961. Francis E Dec is currently 35 years old, and he has a schizophrenic meltdown, writing about a communist gangster computer god, sending flyers all throughout the street into random mailboxes to random addresses around the United States and the world. But why? Everyone knew he was predisposed to such a thing. His parents saw it, his brother saw it, no one treated him very nicely because of it. But this time in 1961 also coincides with something important. It's the end of the trial that we are about to talk about today. Not the very end. Not the end of the original trial. The end of the process. Every chance for appeal has been exhausted and denied. But now that we know how the story ends, why not start from where it becomes relevant? Unfortunately, we do not have the original trial documents. I would love to go through these original trial documents. Allegedly, they are 991 pages long. And this is where I will make my first public plea. If you are a lawyer, preferably in New York State, and you know how to retrieve ancient legal documents, I would request earnestly that you contact me at my email in my About page and on screen, and I will verbalize it, occultwormspeaker@gmail.com. I'm willing to consult you. I am willing to do basically anything to get my hands on these, because without it, we are only working off of what Francis decided to write down, which everything we have can paint a clear picture, but nothing does quite like a stenographer's records. Secondly, when our view starts is an appeal to the New York State Court of Appeals. He has written to a different court at this time, but I wish to save that for a later moment. The inciting event happened in October to November 1956. These events happened and led to an indictment filed February 1958. The trial took place in October 1958, and the appeals process took to 1961, where we would leave Francis E Dec at the terminus of his insanity. But what could have brought him to this point? What could have broken his faith in the legal system or the world so much that he ended up there? Well, in the end, he was convicted on 2 counts of forgery for signing and uttering and disposing of a forged site draft made to one Elizabeth Verschning. Then the second charge of forgery for deceitfully making a certificate upon the general release that Elizabeth Verschning said she executed. Speaking on her behalf without her permission earned a misdemeanor. He was also convicted on 1 count of grand larceny, and if you don't know what grand larceny is, think of it as theft but for non-tangible things, wire fraud, stuff like that. Usually embezzlement of government money. And this was for taking a site draft, the one that he forged, worth $400 in 1961 money. If you're wondering, that's rounded up about $5,000 nowadays. He brought this to the Allstate Insurance Company under fraudulent representations and pretenses that she had been treated by a one Dr. Milton Robbins for bruising on the right shoulder and the right thigh, and that it was a valid and good general release. I make no comments on these things right now, but this is the basic information you should know going into the trial before we discuss it. Now, as he will state later, the maximum time for these charges that he is facing is 2 to 5 years in jail. He never served a day of this, or maybe he did. We'll get to that later, much later. However, he also didn't apply for reasonable doubt and suffered automatic disbarment for the commitment of a felony. Now, I'm told disbarment is a pretty harsh punishment, and if you don't know, all lawyers have to take a test called the bar. You may have seen this dramatized in some TV show or another, but when you pass this test, you are admitted to the bar of the state that you are in. You've effectively passed the bar, and disbarment is a long and arduous process to get back once you've fallen out of favor. But I want you to think about 3 questions as we embark on this journey, because it will be a journey. If you look at the runtime of this video, I don't know what it is as of recording, as I'm recording this in chronological order, but if you look at it, it's bound to be a monster far longer than I have ever produced in the entirety of my career up to this point. Well, career. This set of notes that I have is 11,328 words long, consisting of 72,936 characters. That's including the quotes from the text. But the original appeal briefs, there are two of them that we will go over today, and two accompanying documents to each. That the one to the New York Supreme Court, Second Appellate Division, in case that's important, is 45 pages long. The second one, that I will elaborate more on later, is in 5 parts, each of 20 pages, about 100 to 120 written pages in total. That's not even to mention the insane amount of legal paperwork that will be generated on this journey that I will tally up at the end, hopefully, to get a full idea of how much this man was writing to defend himself, and just for the purposes of sifting through and collating all this writing into these notes, I will do my one token gesture. Please give me a like, a comment, and a subscribe. I do this all for free as a service to myself and for an archival sense of duty. It's very simple. Just please hit the 4 buttons. It really helps my channel a lot. And the YouTube algorithm is far more finicky and harsh than the computer god ever could be. So please, I beg of you, if you have just one word of pray for me, Speaker, give me a like, comment, and subscribe. I don't know how long this will be, but I hope its length and content is worth those things from you. But I want you to hold 3 questions in your mind. What is Francis's angle? By which I mean, why is he representing himself? It is probably the worst thing you can do as a lawyer. Not speaking as a lawyer, but being told by a lawyer that it is the worst thing you can do. Because you can't take yourself out of the personal aspect. And if you can, you should probably be in an asylum. So what is his angle in representing himself? I'll try and attempt to answer all these questions at the end, but I want you to keep these in mind. The second is, where does the computer god play into all of this? And if you have no idea what that means, I will try and illuminate you as we go forward. But just know that the computer god is at least a player in this trial. And the third question that will be asked by the man himself multiple times throughout this is this a fair trial? That may seem like a simple question. This is my first time making true crime content, but I've watched a lot of it, and I know that most people assume, until given inklings otherwise, that a trial is fair. But I want to give you that little poisoned well. Keep in mind, is this a fair trial? Decide for yourself. Don't let Francis tell you. Think about it. Think if the court is giving him a fair shot. And at the end, I will illuminate the answers to all of these questions. But to start, I wanted to give a bit of a dramatis personae, those people who we're going to be interacting with on this journey. Starting off, I've already mentioned 2 of them. The first is the victim in this case, in more ways than one. Her name is Elizabeth Verschning. She is a 20-something-year-old New York resident. She is involved in this whole mess because of a small car accident. As you can tell by me describing the injuries earlier, nothing very serious happened. And depending on whose story you believe, doesn't really change that either. It's a very minor injury that got her into this whole thing. She will be illuminated more as possibly the second protagonist of this entire story, and as more relevant details are espoused, I'll try and holistically bring them together. Once again, at the end, I know I'm saying that a lot, but I want to bring together these holistic characters, who are real people, by the way. If any of them are still alive, I don't wish to misrepresent them, but as far as I know, all of them are not in the picture anymore. So if you are, and you don't like yourself being in this video, please just let me know. If not, I don't wish to misrepresent any of their memories. As far as I know, everyone involved in this is no longer in the picture, thus it's okay for me to cover it. I am going to be making my own conclusions. The intention is not to smear anyone in this video. I don't wish to disgrace the names of those who cannot retort in their best interest. But with that out of the way, our second dramatis personae is a Dr. Milton Robbins. Dr. Milton Robbins is a nervous doctor, and allegedly treated Elizabeth Verschning for her injuries. I know these are quite bland, but I just wanted you to start cementing their portraits in your head, because I'm going to be using these throughout the whole video. I paid good money for these. By the way, these dramatis personae images, because these people don't have any photos of their own, are done by my artist. I don't want to say they are my artist, but if you see any art that isn't available anywhere else on the internet, they did it. Their name is Hallex. They're very good at what they do. Their link is in the description as always. Please, they're great for any type of art, although they do specialize in one type. Check them out, tell them I sent you. Might be a nice way to let them know that I and they are being heard on the internet. More dramatis personae will be added later, but starting with the New York State appeal to the Second Appellate Division New York Supreme Court, we'll start with the outline of the people's case, which I feel is one of the most unbiased ways that you can start an appeal brief. Starting all of the starting information and going into what is effectively, it's the most unbiased way to look at this trial if you're looking at an appeal brief. Because an appeal is going to be written, especially if you're representing yourself, from the perspective of an interested party. So I want to use this outline of the people's case as a groundwork for what we're going to work off of. I'll try and summarize the key points on screen as they occur, and I'll keep you entertained with the little dramatis personae of who's in the scene. But let's begin. The outline of the people's case is as follows. On January 9th, 1956, Elizabeth Virschning was involved in a car accident, a minor one, no one was killed, and consulted Dr. Azara, who was their family physician at the time, which was the only care that she received. This care was to treat a broken wrist. The Virschnings, did I mention that Elizabeth was married? She and her husband, Fred Virschning, sought out and retained a lawyer by the name of Francis E Dec, while their injury and loss of services claim were being processed. In May of 1956, 4 months after the accident occurred, she goes to the doctor for the Allstate Insurance Company, Dr. Rosenheck. In October 1956, Charles Martino, the examiner for Allstate Insurance Company, negotiated with Dec for the treatment that Dr. Robbins provided, which amounted to about $48 or $200 in today's money. The negotiator wrote a check for $400 to Dec and Elizabeth Virschning. He then presented the check with 2 signatures to Allstate and received $400. Fred nor Elizabeth Virschning never signed any general release, nor the check, nor knew about any relation to the case. They also did not receive any money, nor gave permission for Dec to sign their names. In February 1957, Allstate, performing their due diligence, goes to check that Elizabeth Virschning has received her settlement money, and Elizabeth states that she doesn't know what's going on, effectively says that she has received no money, she has received no updates on how the trial has gone or how the claim has been processed, and once again that she has received no money. Quote, further, Dr. Milton E. Robbins knows nothing until many months after the case was settled, of July 5th, 57, as this case is now investigated. On a Friday night, the defendant, Francis E. Dec, goes down to see Dr. Robbins and says he has a typewritten statement of this bill that was sent to Allstate to settle the case. He says to the doctor, I want you to copy this statement exactly, as I have it in your handwriting, because I need a copy for my files. And the doctor foolishly, in July 5th, 57, gives Francis E. Dec that requested medical statement, unquote. You're already beginning to see some holes, I assume. But let's continue with the summary. Dr. Milton Robbins is then visited by Detective Becker on July 8th, and Francis returns later that day and asks for x-rays, and is given hundreds, which he gives to a garbage man. The state then lays out the charges, saying that because Francis E. Dec is a notary public at the time, he had to know it was forged, and he is also charged for the larceny of $400, which Elizabeth Virschning never received. Now, let's update our dramatis personae. Let's start with Dr. Azara. He is a very minor character in this story, but still very important, especially to the state. He's the family doctor of both Elizabeth and Fred Virschning. His role is not to testify, but just to provide an account of his actions, and that is effectively Dr. Azara's full development. But let's mention a larger dramatis personae, one who will gain a lot more wrinkles and furrows as we go through this story. Let's look at Fred Virschning. For now, we know that he's Elizabeth Virschning's husband. He basically accompanies her wherever she goes in this case, and that is as important as he is for now. Also, we have a slight mention of a Detective Becker. Becker is going to also be a lot more important, but this visit to Dr. Robbins is also going to be very important. Detective Becker comes out a lot more in the trial-oriented parts of this appeal brief. We also have a Charles Martino, the insurance examiner slash supervisor. It's a little unclear where he lies, mainly because we don't have access to the trial documents, which would fully elaborate what his position is, because he's called by Francis as a supervisor, not a negotiator. And the state claims that he negotiated with Dec for this $400 settlement. And don't worry about the contradictions. There are going to be a lot of them. I'm going to let you decide for yourself as we go on what you believe to be true. And at the end, I'm going to lay out what I fully believe is the true story. Although they effectively say what I believe to be the true story, but I'm not going to get ahead of myself. This has to be a slow, plodding march. Now, the state has laid out its case. Effectively the accusation, and coming from a point of strength, as since this is an appeal brief to the New York State Supreme Court Second Appellate Division, they are coming from a strong position. They are the sentence as it currently stands, and Dec has to provide overwhelming evidence to prove whatever angle he's going to take. He begins with a quote that I will read in full. Quote, "Defendant is innocent of the crimes charged, and that the crimes charged were fabricated through the assistance and coercion of the district attorney and his staff, with the convenience of the other important members of the Nassau County judiciary and government. After a decade-long period of persecution through a legal prosecution by the said various officials because of the defendant's righteous complaints of corruption of some said officials, the indictment of the defendant, a lawyer, in secret, without notification to the defendant, as promised by Frank Gullotta, the district attorney, personally to the defendant, constitutes an unprecedented, fanatical effort by the various officials to gain revenge by falsely, feloniously convicting the defendant and thereby ruin defendant on the ridiculous, contradictory complaint of one perjurious, young, neurotic woman client," unquote. In case you're wondering, that's Francis talking about Elizabeth Virschning when he's talking about the perjurious, young, neurotic woman client. So, to add that to the dramatis personae, Francis's perception of her is not very good. But second of all, I want to add someone who's going to be a major character in this case. The Nassau County District Attorney, Frank Gullotta. We really only see him through a negative light, and history has not come down as anything more than, he existed. He had one famous case, and he became a Supreme Court judge. Most of what we know is from Francis E Dec, and I will let you know some of it is allegedly true, mainly because I have not found anything to contradict it, and also I found some things that may suggest that it is. We'll once again keep you updated throughout the course of this video on Frank Gullotta as we learn more. Now, after this quote, Francis elaborates, saying he was brought on as a retainer, and revealing another part of Elizabeth Virschning, mainly that she had been suffering matrimonial issues. He says he quickly became as much as a retainer as a counselor to listen to Elizabeth Virschning's abuse and matrimonial issues coming out of her marriage. She brought this insurance claim partially also for it to be a legal separation retain. So she, if you believe Francis, this is meant to be her retaining him for a separation action as well as this insurance action. Francis then contacts the Allstate insurance adjuster, a Mr. Urso, to remove Fred Virschning from his legal services. This is pending the separation action. He is no longer serving them as a couple. He is now serving purely Elizabeth Virschning, no longer her husband at the current moment, Fred Virschning. He then settles the claim for $400 with the Allstate insurance adjuster, Urso. Charles Martino never negotiated. His job was to oversee, not to adjust. He approved this payment, but did not negotiate it. This is Francis's position. Now, Francis refused to proceed until Elizabeth Virschning had gotten a bill from Dr. Robbins. This is backed up by Fred Virschning, who had picked up the written bill from Dr. Milton E. Robbins. He did this so that Francis could finally proceed with the legal action and presumably get him his money and loss of services claim settled. This bill was then used by Dr. Rosenheck, the Allstate insurance company doctor, when Mrs. Virschning was examined by Allstate, the insurance company. She never disputed anything on the bill, and Virschning also claims that these two identical reports are false. Interesting. Dr. Azara, bless his soul, Francis asserts is a pregnancy specialist. This is to discount his treatment and effectively say that Elizabeth's visit to him was for her pregnancy at the time, not to treat any injuries. He also says that Dr. Robbins's testimony during this trial of ignorance and generally not knowing what was going on are false, as there's a key moment that will be revisited multiple times, which is Frank Gulata, Milton E. Robbins, Francis E Dec, and Fred Vierschning inside of the district attorney's office. And in this first time when we look into this scene, Fred Vierschning breaks down and confesses to retrieving the medical bill, as Francis said. Also, he likes to add a lot that Dr. Milton E. Robbins is a perjurer and a liar, and asks that, quote, further, Dr. Robbins will admit that when he first went to the district attorney's office without any lawyers and gave his unpremeditated, impromptu, extemporaneous answers to the district attorney, he stated in detail his treatments to Mrs. Vierschning for the injuries stated in his medical bill, which the indictment claims false. Dr. Robbins also admitted that in order to collect the medical payments from another insurance company, he, Dr. Robbins, forwarded defendant stationery to make a copy of his bill, because he, Dr. Robbins, kept no records of his bills. Dr. Robbins will admit that he did not conspire with the defendant, Francis E. Dec. Dr. Robbins will admit that he knew that the defendant, Francis E. Dec, was retained by Mrs. Vierschning for an impending separation action, and that the defendant, in accordance with the agreement with Mrs. Vierschning as her lawyer for an impending legal separation action from her husband, defendant was holding her $200 share of her settlement money in escrow as part payment toward a legal separation action. Dr. Robbins' story of knowing nothing until July 1957 is completely false, and the concoction of Dr. Robbins, his brother-in-law, who is a lawyer, and J.D.C. Murray, a Nassau County lawyer and friend of Frank Gulata, ex-district attorney of Nassau County, that this story of knowing nothing was concocted in concert with these two lawyers during a period of weeks after Dr. Robbins stated his first extemporaneous true statement and answers to the district attorney, end quote. So, what does Francis claim in this statement? First of all, this trial takes place after this meeting, and this trial, Dr. Robbins, according to Francis, gives a testimony that was concocted by two lawyers, one of which is a friend of Frank Gulata, and he states that before, when he was in the district attorney's office, Fred Vierschning admitted that he had gotten the bill, which, to Francis's story, is true. He also says that Dr. Robbins effectively goes against his testimony in court and kind of hints at what I believe is truly going on, especially with the he did not conspire with the defendant. Will admit he knew the defendant was retained because he's effectively looking for people to back up his story, because when he asks Dr. Robbins to confirm these things, he's asking for more proof that his story is correct. And considering that Dr. Robbins did not admit this in court is a little detrimental to his case. So I can understand his frustration. Now, after this meeting in the district attorney's office, the one where Fred breaks down and Dr. Robbins effectively backs up everything Dec says without saying it, Dr. Robbins frantically tries to contact Dec. And when he does on July 8th, he says he fears his brother is under investigation by an Arkwright committee for ambulance chasing. Now, let me give you a little bit of a background on what this means. So an Arkwright committee is effectively an elected group of officials that determines good federal government or ethics questions. And ambulance chasing is lawyers when they're looking for work. Sometimes, this is not the best, I'm told, not by a lawyer, but kind of just by common sense, that when someone gets injured, ambulance chasers are usually the people who follow the ambulances to wherever they are and try and get the people injured to, like, sign them on to get retained. So effectively, what Robbins is saying is that his brother is under investigation by an ethics committee because he's a lawyer that tries to exploit other people's hardship, especially in times when they may or may not know what they're doing. And over the weekend, because this is a Monday, Dr. Robbins was visited by Detective Becker. He also, while calling Francis, wants him to get back the receipt that he gave to Fred Vierschning for some reason. And Francis really paints him out to be kind of a character in this. Super paranoid, super, like, out of sorts, emotionally incontinent. He's described as hysteric. He threatens to harm himself unless Francis disposes of all these x-rays to cut any ties of Robbins to his brother. So Francis does so. He puts them in the back of his car and hands them off to a garbage man. Dusts his hands of it, all done. Secondly, he addresses Elizabeth Virschning's claims, which I will introduce as he addresses them. The first claim is that Elizabeth Virschning only saw him in person once. Francis says that this is ridiculous. And he also says that all the signatures that the court says are forged actually aren't forged. Source? There's your source. And, well, sorry, actually, he does give proof. He says she includes her middle initial on her signature, which is not on any of the Allstate records or Francis's personal records. Now, Francis's legal fee is $450, $200 for the insurance claim, and $250 for the separation action. So, he says, I'm already taking my half for the insurance claim, the $200, and for the $250 for your separation, since it's the 50s and you have no personal income, you should just give me the $200 from your insurance payment. And this will be held in escrow until the rest of the $50 is paid for her separation action. Francis alleges he was promised $150 if she pulled out of proceedings for services rendered at this point, probably because he had done some preliminary work or he was just trying to get some money out of it if he could salvage anything. And until he received money, he would look for solutions to her marriage troubles, whether they be amicable or not, but wouldn't proceed with any of them. He then brings this to Fred Virschning, who said that effectively he would continue to treat his wife how he treated her in the past unless she forgot all about it, which is another character trait of Fred Virschning. He's not necessarily, even in the people's view, which is unbiased, and Francis's view, which is biased as heck, he's not a nice guy. Keep that in the back of your head. He would also, by the way, continue his life of debauchery, which Francis is very explicit about, saying he's sleeping with these ladies of the night and stealing cars down south to sell them up north. Repeatedly in his writings refers to him as car thief, debaucherous scum, Fred Virschning. But anyway, Fred then learns by coming to Francis's office, asking him to stop the separation action of the escrow money, which nowadays is more of an electronic payment service. It's held in like a vault or something. I don't know how it works. But apparently Francis was keeping this escrow money in a envelope, not held by a third party, but held by him. And Fred Virschning found out then, during this time, after he finds out about the $200 in escrow, he had only been working with Elizabeth Virschning for a couple weeks. Then he returns a couple weeks later, claiming that his wife is no longer interested in separation. However, Elizabeth Virschning contradicted this, and Fred continues to get more aggressive, demanding that he return the $200 in escrow if he knows what's good for him, quote unquote. And Francis says, after this, I tried to contact Elizabeth Virschning and I couldn't. Like, I'm talking multiple times, schizo X type deal, I'm trying to call you, you're not picking up, and Francis gets a little worried. Fred Virschning then begins to visit his office more often, and Francis accuses Fred of trying to defraud him, aka you're trying to get away with this $200 I've rightfully earned, because remember he was promised $150 services rendered if Elizabeth forgot about it, but remember he hasn't heard from Elizabeth yet. But during this period, it's debatable about head of household rules, but this is where the meeting happens. The meeting, Francis and Fred are called to the DA's office, aka the district attorney's office, who is at the moment Frank Gullotta, where he stated everything I've just told you. He tells the district attorney the entire story, and he says, if this is going to trial, I want to be informed of any grand jury hearings. Frank Gullotta says, yeah, sure, I can do that. He was then taken in custody back to his law office by Detective Becker, and then told Detective Becker everything above. Tells him all about the Virschnings, the $200, the separation action, the $200 in escrow, and, you know, all these receipts that he has, and Becker then steals them, or purloins them, claiming that these documents are fake, as did the district attorney, but Francis knows these are real. This is just a slant that the DA is trying to discredit his very real evidence. Detective Becker also throws in a couple sly things, saying Francis was never an ambulance chaser, and he was never retained by the Virschnings because they never signed a retainer. Now, this is a character trait of Detective Becker that I think makes her very, very charming, especially in this story, is that she's the no-nonsense detective who calls everyone out on their nonsense. She's going to be the one. I know it feels so bad, but I have to say it. Whenever you watch true crime, I can't help but feel, not for like sympathy for whatever they did or whatever insane thing they're convicted of, but just how they're treated by detectives. I always feel sort of bad. And Detective Becker is the one that I would hate the most, because this person's going to be telling their story and they'll just say, no, you didn't. And that'll throw them off their guard, because they'll say, oh, there was this retainer. I was retained by the Veer. No, you weren't. Where's your retainer? And obviously he has no answer. Or, I have all these documents. There's this 200 and that. No, you don't. Where's Elizabeth Viersching's consent? If I call her right now, is she going to consent to you signing that form? Because I know that's not her handwriting. She's going to be the one who calls Francis out, and he is livid. This makes him frustrated to no end. But think about the two contrasts in these overall stories. One is very, I don't want to say patchwork, but it holds together. And this is Francis's representation of the people's case, by the way. It's got some holes, but it kind of holds together. And his is way longer, way more rambly, involves a lot more vague words like conspiracy and conspired, and it has a lot to do with justice. You know, this has been going on for years because of my honorable complaints, and the DA has all these other things to say about me which aren't true, and Dr. Robbins is a perjurer and a liar and all these other things. Notice the two different tones. I want you to keep those two different tones in mind, because we're going to sink fully now into the appeal part of the appeal brief. Obviously, you would assume the appeal to be in the appeal brief, but you may, in a sense, question why he would be asking for an appeal. Now, you can ask for an appeal for a lot of things. Usually a miscarriage of justice. You feel that there was discrimination involved on the part of the judge or the prosecutor or a whole number of things. But usually it's because something's weighted in a way that is unfair and unjust and wouldn't be the same if you had taken someone else and put them in that exact situation. It's that thing called burden of proof or reasonable doubt. You have a standard to meet. You have this burden of proof to go over to prove someone guilty. Because in the United States, you are innocent until proven guilty. That is an honor extended to everyone. And you may think, what is there to contest? If he's going to make claims of conspiracy, he has to back this up somehow. So this appeal brief, in its first section that isn't just restating the facts of the case, it is a section titled Defendant's Pre-Trial Challenges of the Indictment. So before he goes to trial, he's going to make these challenges because he can already see that this is going to be a biased trial. If we're going from his perspective and point of view, he sees that this is already going to be an unfair trial. People shouldn't waste their time. He's trying to cut it off at the pass before it becomes anything more than what it should be. And he mainly begins at the very first start with the grand jury hearing. Now, if you don't know, a grand jury hearing, I was almost involved in one, but a grand jury hearing is where the prosecutors go forward and bring forward all their evidence to a jury of people who couldn't care less. They're probably getting paid $40 a day because this is New York. And they say, do we have enough evidence to pursue a trial? And the grand jury will go out, they'll vote, and if they do, it goes to trial. Yippee. If it doesn't, case dismissed. No longer a problem, or it's something more minor, or they'll issue a fine or something. Basically, you are determining, is this big enough for the state to warrant a fast and fair trial? Obviously, because it went to trial, the grand jury voted yes. But if you'll remember, Mr. Francis E Dec, Esquire, at this time, requested to be informed when a grand jury hearing happened. He was not made aware of this. So, he says, since this promise has been violated, I'm going to make multiple motions to inspect the minutes of the grand jury hearing. He also makes a lot of motions just to flat out dismiss the indictment. Basically saying, all of this is made up, it's fake, you didn't even invite me to the grand jury hearing, even though defense attorneys usually aren't there. And he even goes so far and is so worried about this case that while he's like, you're gonna notify me of the grand jury hearing, right? Oh, yes, of course. You're gonna let me know of the grand jury hearing, right? Oh, yes, of course. He harasses the DA and the DA assistant multiple times, first of all, legally, basically just by calling them, and secondly, through subpoenaing for a non-existent grand jury hearing so he can just talk to them face-to-face and ask. He's basically shooting out probes to see if it's happened or not, because if you can't subpoena something, it doesn't exist. exist. But this is never prosecuted. It's probably just a fine or something. I don't know how bad illegal subpoenas are. Once again, if you're a lawyer, please put it in the comments section. I would love to know, because I am not a lawyer and I am so far divorced from the legal field. I've only had like family members who are lawyers, and it is the most arcane, magical thing that I have ever seen. Major respect if you're a lawyer. Anyway, after he's done all of these efforts, basically verbally informing the DA, verbally informing the DA assistant, trying to illegally subpoena a grand jury minutes that doesn't exist, he breathes a sigh of relief, wipes the little bit of sweat off his brow, and says, "I'm glad this isn't going to trial." Immediately, he then says, "This meeting was held in secret 8 months later after these requests without notice. Therefore, I couldn't challenge anything." Which I wonder if it's purposeful or not purposeful. Frank Gullotta has a history of hand-picking his juries or being very intense about the filtering for his juries. That is what we do know. I'm not trying to insinuate anything beyond that, but the one case he's famous for, he took a pool of 250 people and boiled it down to 12. So take that with a grain of salt. Francis says that because he wasn't involved in the grand jury hearing to challenge anything, this violated his rights to a fair trial. You may be getting an inkling of where that third question is coming from now. He also filed 2 motions to dismiss the case, both of which were dismissed by 2 different judges, one by Judge Hogan and the other by Judge Brown. Now, this is where I'm going to be a little hazy, as Brown says that this second motion to dismiss is a demurrer, which is basically a complaint or an objection around that level, because his first one was filed in the wrong court. The second one that he made is technically filed illegally because he's already made a motion to dismiss, and he refuses to accept Francis's version of the case. He doesn't find overwhelming evidence to the contrary. He gives him the runaround and ultimately rejects his demurrer, and the motion to dismiss officially, since it was filed in the wrong court, is dismissed as well. He then places some legal precedent. He says, quote, "Judgment contrary to the weight of evidence. Judgment below standard of rebutting the presumption of innocence as set forth in section 389 Code of Criminal Procedure," unquote. Effectively, Francis saying, you don't have enough evidence to convict me, why is this going to trial? Then, in quite a twist move, he says that the prosecution's witnesses and the judge, everything they say in the court, in fact, confirms his innocence. Respectively, the liar and perjurer, Dr. Robinson and Elizabeth Virschning. And these testimonies that they gave are, in fact, removed by the court clerk and or stenographer, one of the two, but he says clerk in his appeal brief, in order to strengthen the prosecution's case. This will be another running theme, and later on, he will submit an alteration document attempting to correct the court record, but we're not there yet. Just know, Francis says that you can't convict me because you don't have enough evidence, and you've been removing all of the evidence that I can use from the court record. He asserts that Elizabeth Virschning knew him very well before the case, and her examination done by Dr. Rosenheck, if you'll remember, the insurance company doctor, is consistent with the injuries to the right shoulder and thigh, with nothing about a broken wrist. Remember? In the People's story, Virschning went to Azara for a broken wrist. However, in Francis's story, she was treated by Dr. Robbins, and upon being examined by Dr. Rosenheck, gives the exact same diagnosis as Dr. Robbins. Elizabeth Virschning also claims under oath she was pursuing separation and called about it repeatedly, and because she had no money at the time, was well within her rights to give up money in escrow, aka, I'm not holding this money because I'm stealing it, I'm holding this money because she legally gave it to me for services rendered. Dr. Robbins also confirms matrimonial troubles under oath, and Charles Martino confirms it is all state policy that the money is the legal domain of Elizabeth Virschning. This is because there is I don't want to say a stipulation in New York state law, but at this time, unless the husband and wife were undergoing separation or were divorced, the money was entitled to the head of household. I mentioned that earlier. So technically this would be Fred Virschning's money if she weren't pursuing separation, which is a key part of Francis's case. Francis also says, once again, that Martino never negotiated, and it was all Urso, the insurance adjuster. Martino only approved the money and signed off using the available information. He then reiterates how Detective Becker took him back from his visit to the DA's and explained how escrow money works. Since I've already done that, I'm not going to to do that in the same way. He then says that the statement used by the prosecution was discounted by Elizabeth Verschning upon his cross-examination of her. Keep in mind, he will call no witnesses during this trial. He's mainly working off of whatever the prosecution will give him, and contradicted her original testimony once again upon cross-examination by Francis E Dec, admitting that the misspelling of her name was true under oath. Francis then reiterates that this misspelling does not exist on any records anywhere, meaning that either there are two options: she signed a document and then it never made it into any, notable repository where it might have been saved, or B, she never signed anything at all and this is just a complete non-point. Or maybe I'm missing something, but I don't know why he says this wasn't in my records or the Allstate insurance like, wouldn't you want this to be in your records? Or because aren't you proving the prosecution's case? Anyway, because there's a minor thing. Going back to Elizabeth Verschning, she was recently married when this accident happened, and she was having trouble spelling the last name Bierschning, which I also have the same trouble spelling. But she says, oh, this was only within the first few months of my marriage. After that, I got over it. And it's at this point you also get to see that the court is a little more interactive. He's about to ask her a question. Dec asks Verschning the question whether she signed the check, and the court stops him. This is where we get to introduce to the dramatis personae the prosecutor, Arthur Nixon. He interrupts with, I object, Your Honor. That is ultimately for the jury to decide in this case, and the court sustains the objection. Now, to introduce you a little more to Arthur Nixon, this is an experienced lawyer, late 30s, early 40s. He's a hotshot prosecutor for the state, and a lot of times in this story, I suppose, you will hear a statement something along the lines of, the objection was sustained, and Francis's intent to appeal was noted, or something along those lines. It's in legal speak, but that's effectively what it is. It's basically Francis saying, all right, we'll settle this in the appeal, I suppose. And he says that a lot, especially throughout this second appeal that we're going to go through. And he says that this is a concerted effort by all parties to obstruct the case. And he founds his right to appeal on the obstruction of his cross-examination. The cross of Dr. Robbins actually would reveal, if we had it in full, that Robbins cooked up the story that the prosecution used with his lawyer and brother during the 2-week period in 1957, after he had gone to the DA's office, told the DA everything, with Fred Verschning and him in the room. And Francis then ends this section saying that the evidence against him does not meet the burden of proof to convict. I don't know about you, but the jury was unanimous. Not saying that amounts to anything, but based on some more things we're going to get to when he takes this appeal to a higher court, I want to cover it then. You decide right now whether he's met the burden of proof in your eyes. We obviously don't have access to a lot of the evidence, but it should be apparent that he hasn't cited evidence. He hasn't even cited parts of the trial in any meaningful capacity. He doesn't have any hard evidence. All of his quotes are just him scrounging what he can from the trial record. But this was just all of his attempts to dismiss the indictment wholeheartedly. Second, he makes note of his motions for mistrial. Now, mistrials are nebulous, but you may hear the word thrown around. It's usually a special circumstance when something happens outside of the control of the court. You know, someone flipping out, or the judge doing something uncouth, or the prosecutor, or anyone involved doing something crazy, or a bunch of reasons. Basically anything that would obstruct the court from being able to perform its legal duties in an unbiased way is room for a mistrial, as I understand it. Once again, not a lawyer. So to begin off this section, motions for mistrial, Francis makes multiple attempts to dismiss this as a mistrial, which the one he will harp on the most is the week-long adjournment just 2 days after the trial begins. He makes a big deal out of this, but it will be explained later why. A lot of these, if you feel that I'm leaving you hanging, are explained in the appeal to the higher court, but I'm getting ahead of myself. Keep all these holes and contradictions in your head. They will be answered in due time. Also, the court discontinued the cross-examination of Nathan Burchell, the DA stenographer, another addition to our dramatis personae. Nathan Burchell, or as he will be called by Dec a lot, Nat Burchell, is a veteran stenographer for the court. He has 30 years of service under his belt, and he is well known by basically everyone who has done a trial in Nassau County. He is the stenographer, and the fact that he is here shows that he has, or that this case has some merit. And the reason why he's being examined will be explained. But just know that if he's being crossed, that means he was called as a witness at some point, because how it works is you're called as a witness by either the prosecution or the defense. The prosecution or the defense, whoever called you, will effectively ask you a bunch of questions which you have to answer honestly, because they get you to swear on the Bible or whatever other thing you want to swear on that'll make you tell the truth, and the whole truth and nothing but the truth. And then the cross-examination is whoever didn't call you, being if the prosecution called you, the defense gets to cross-examine you, or if the defense called you, the prosecution gets to cross-examine you. And they usually try and poke holes in your story or ruin your credibility or one of the two. It's way more nuanced, once again, not a lawyer, but that's how I understand it. So this stenographer, by the way, who was recording the case, being brought as a witness is a little, I don't want to say unprecedented, but it's weird. And he also had his cross-examination of Elizabeth Vierschning discontinued after she admitted everything in Francis's story up until now. Effectively, they had to adjourn because he was getting too much out of the stenographer and Elizabeth Vierschning. And after this, after they had said, no, you can't cross-examine these people, this is when his first mistrial request was filed. He had, up to this point, objected to these irregularities, court objections, basically saying, I object on this grounds, usually relevance, or speculation is another common one. But there's a big book of rules that people are supposed to follow while in a court, and objections are basically you calling someone out and the judge decides whether or not your objection is valid, which is why you hear objection overruled, which means they can continue, or objection sustained, and then the judge will normally say something along the lines of the most common example. It's also a strategy because it's never going to be let through, but it's brought up in this case. If you're on trial, this is how I heard it, if you're on trial for stealing a cookie from the cookie jar, you could say upon your cross, is it true that you are a known thief? Now, this question is too general for it to be relevant. Defense attorney will, of course, say objection relevance. Judge will say sustained, strike it from the record. Please continue on a different vein of questioning because that is not relevant. But you still poisoned the jury's mind. They say, you can't have this in your ruling, or you can't take this into account because it's off the court record. But that's a strategy that you can use if you're a lawyer, or I've been told you can use. And Francis is just basically objecting. I assume they're rejected, mainly because they don't go anywhere. And his first mistrial request was denied for not being able to cross-examine two witnesses, and this is all from his point of view, by the way. I want to stress that. This being from his point of view, because we only have his point of view, and I'm going to try and dig out the truth from this. There are going to be some points when the state actually gets to represent themselves, and that's when we can do more. But I want Francis to set up his whole story because this is a founding point when we go into the further ones, because he's just going to restate everything and add some stuff. So I want you to fully understand what happens. He also claimed that the judge was discriminating against him and he was biased towards the district attorney, basically saying he was in Frank Gallotta's pocket the entire time, and he was getting some kickbacks or some other form of reward for following this he doesn't say gangster police court, but he also brings up that he's Polish. This is also the 50s. He's probably facing at least a little bit. I don't want to say a lot, but Cold War's going on. Poles are behind the Iron Curtain. He's a Polish American, and you know how, hyphenated Americans, Irish hyphen American, were treated during the World Wars and other stuff like that. So he's probably got at least a little bit of credibility there. But he also included restatements for prejudicial statements, namely that, quote, the defendant was the cause of wasting the court's day and the jury's day on Thursday, and the day that the defendant wasted was a beautiful day the jury could have spent playing golf, unquote. Yeah, guys. we could have been golfing and this guy wasted our entire day, wasted our time. But that's like another little nugget of truth, right? You get the feeling that he's kind of, I don't want to say stalling, but he's being a nuisance. Keep this as a theme, because the court then shows him a little bit of mercy. The court gives him a little bit of time to read the stenographer's notes, Nat Burchell's stenographer's notes. However, Francis, achieving what he wanted to in the first place, then takes jabs anyway that says that reading his notes would be biased regardless, and that, you know, reading them wouldn't even be beneficial to his statement. And then he proceeds to be just a general nuisance, calling for the entirety of the notes to be read for the jury to support his case for a mistrial, which is completely unheard of. You're basically doubling the entire length of the trial, because even if it's 10 minutes long, you say, hey, let's read all the court minutes. You then have 10 minutes of reading 10 minutes, and you now have a 20-minute trial, which could have just been 10 minutes. Of course, they don't humor him. They say no. And after this one-week adjournment, the court goes to get a different stenographer. And here's a little bit of trickery here. Not that it is necessarily underhanded, but they seem to want to nail him on a bunch of technicalities, because they're finding out he's not very good about technicalities. He really only likes to harp on the things that he's strong at. So because they're switching over to this second stenographer, and it's not Nat Burchell, this second stenographer has no notes to work from. So when Francis requests that they read the stenographer's notes, there are no notes to read because the second stenographer hasn't even taken notes yet. Francis then requests that the new court stenographer go retrieve the previous minutes and read them. The court, or the judge, effectively tries to dissuade him by saying, when I read things like this, saying like the court tries to dissuade him or the court gives leniency, they're basically humoring him. They're giving him as much leniency as physically possible. And it's another window into, if you've watched a lot of true crime, when people represent themselves and the court gives them an insane amount of leniency, it's usually to prevent them from appealing, because they can just go back and say, hey, we gave this guy basically every single thing that we could possibly give him without giving him just flat out an illegal trial, and we gave him all this advice that we probably shouldn't have given him anyway, but this proves above and beyond a reasonable doubt that we have endeavored to give him every shot at a reasonable trial that we could. But that's just my vibe at this moment, because they basically say, hey, you probably shouldn't do that, and then they just flat out say no. And then they say, go ahead, saying, quote, the defendant is ordered to go ahead. Defendant takes objection, but the court reorders the defendant to move ahead, and the defendant stresses that, quote, under our law, I am forced to proceed when your honor denies me the right to object, unquote. The court states, the court feels that everyone here is well advised that we are contending with proceeding from that point. Substantially, the judge states he, the judge, the prosecution, and the jury are well advised and are agreed upon in their opinion of the defendant. That defendant's trial is but a required formality before convicting the defendant feloniously. What possible other interpretation of this dastardly but revealing remark by the judge can properly be applied to said remark, under the circumstances created by the many other statements and remarks of the trial judge, particularly enumerated in the defendant's motions for mistrial, there can be no other interpretation of such highly prejudicial remarks by the trial judge, unquote. What the judge says is actually extremely damning, because he says the defendant's trial is nothing but a required formality before convicting the defendant. Basically, the judge says, you have nothing. You lose. It's like, I felt so bad comparing him to Dale Brooks originally, but now I realize that that comparison was way more apt than I thought it was. Because they just view this trial as a formality. They don't even view him as like an actual lawyer. They just view him as a private citizen representing himself. And that's the best he's gonna get. He says, oh, this means that the trial was fixed. No, that just means that they had no faith in you to defend yourself. Anyway, he then backs up this statement, citing precedent for mistrial for a prejudicial judge. Oh, prejudicial. Oh, that's where prejudicial comes from. Anyway, he then says, quote, defendant's objection and exception to the admission of the fraudulently altered hearsay stenographic notes of Nathan Burchell, the district attorney's stenographer, said notes consisting principally of conversations of people such as Edward Robinson, Frank Gulata, Detective Alva Becker, and lawyer J.D.C. Murray, none of whom were witnesses during the trial. End quote. Now, because it is now relevant, and the judge is being a little more assertive, I'm sure I've used this image before, but now I can tie it to a name. The judge judging this trial is The judge judging this trial is Judge William Sullivan, an older judge described as highly patient and level-headed. First of all, basically says that the stenographer's notes are altered for the DA's benefit. Second of all, says that these notes consist principally of conversations between other people like Edward Robinson, who is the assistant district attorney at the time, Frank Gullotta, the district attorney, Detective Alva Becker, and JDC Murray, who is an older lawyer. And he really hounds the stenographer about this, because he then goes on to state that Burchell didn't see the written form of his taped notes because he's allegedly taking notes on tape, although I'm not positive that's how stenographers take their notes. And he says that only Burchell could read his notes because he had developed like a secret code that he had developed as a stenographer. I don't know if it's because they have like those nice little specific keyboards that are like allow them to type at 200 words a minute or some ridiculous thing like that. But he really has it out for Burchell, and I don't know why. Because Francis then requests to see the notes and then is denied again, and he then says, oh yeah, this is fraudulent and they were probably stupid anyway. They were altered, they're in the secret code that only he can read, so I mean, why even bother? I didn't even want to read them in the first place. He also then gives us a little bit more of a view into Arthur Nixon, saying, quote, the final summation of Arthur Nixon, the prosecutor for the district attorney, was an incoherent, muddled, simple language outline of non-existent evidence based upon people who were not witnesses and who the prosecution refused to call as witnesses. The court reporter's record of said A. Nixon's final outline is found conveniently on pages 901 to 935, and even this said record produces over 35 objections and exceptions by the defendant to the raving, incoherent, muddled, simple language outline of non-existent evidence based upon such people as those listed in detail below. And then he goes to effectively form his hit list and the fleshing out of some people on our dramatis personae list. He also misconstrues that to be a good lawyer, you have to be super flowery with your language. It's really, I feel, indicative of his style, because I've been told everyone has a style in lawyering. And I feel Arthur Nixon's is very blunt, to the point, pointed, and clear-cut. I feel like he doesn't really mince words, possibly why he may be considered raving, but he also says that, like, oh yeah, the prosecution could have just called them, and he never realizes that he can just do that himself. Can't the defense call witnesses? He called none of them. But anyway, he has a hit list, and by hit list, I mean legal hit list. So he's basically just taking issue with these people, and he's going to tell you why. The highlights are Frank Gullotta being a present specter wherever Dec isn't, and coaching Fred Vierschning and Dr. Robbins as to what to say, aka he was at the grand jury hearing and he was telling Fred Vierschning and Robbins what to say, and he formulated all these things so that he could put me off the bar, onto the street, rig this trial against me. And he doesn't have much more positive to say about Edward Robinson Jr. either, being an incomprehensible mouthpiece solely serving Arthur Nixon, basically Frank Gullotta and Arthur Nixon's go-between. He's also the person that Francis charges with altering the records to be consistent with the prosecution's story and not the facts. And worse yet, he makes a lot of it saying like, oh, these stenographic notes are actually going to constitute a confession, which Dec disputes as precedent, which is also a bit sus for him to say, because my understanding is that stenographic notes are not a confession, but they're also what was recorded that happened in the courtroom. So it's not a confession on paper, but you probably didn't say the best things to help your case. Third, he takes aim at Dr. Azara, saying that, first of all, he's a specialist and not a family doctor, and second of all, backs up that Elizabeth Vierschning contradicted herself by saying that, oh, she went to Dr. Azara and not actually went to Dr. Milton Robbins like he claims, and the prosecution refused to bring Dr. Azara as a witness, which basically means that, oh, they're going off of his statements, but not actually bringing him in as a witness, so I can't cross-examine him, even though he could have called him at any time. The prosecution also refuses to call Dr. Rosenheck, but also makes many references to him in his report, as if these people need to stand in court and be a witness for their evidence to be admitted into trial evidence, which I feel is a mistake that Francis E Dec Esquire, remember lawyer, will be making throughout this entire thing. He also takes aim at Alva Becker, and I can only imagine her smiling throughout this entire section, because he describes her as the super key witness detective who was at the grand jury hearing and works tirelessly to discredit my story. She spotted the envelope and purloined it, and would edit Burchell's trial notes, along with Robinson apparently, and would never be called as a witness despite work being done by Becker held up as key evidence, making her unable to cross-examine. As if being able to you could call her at any time, Francis. This goes for anyone. You could call anyone to the trial. I don't know. It's probably a benefit that you didn't call any of these people, because it already sounds like an open and shut case, just even from your biased perspective. I'm gonna go out on a limb and say this is kind of a one-sided case, mainly because the way the state describes it, and even the way he describes the state describing it, is there are just so many incongruencies. But if you're recognizing them, keep them in your head, because there's going to be what I want to consider the definitive later. He also takes aim at Dr. Robbins' lawyer brother, who is never given a name. He's always talked about by Dr. Robbins' brother, who is a lawyer brother, and he says he's the one who conspired with Dr. Robbins to concoct his know-nothing story, and he got Robbins to manipulate me into getting rid of criminal documents. You remember those x-rays that he gave to that random garbage guy? So they could continue doing crime behind my back and dump me as the fall guy. Which I can say is kind of insane, if not genius, because you went along with it. Why did you do that? I don't know, maybe we'll cover it later. There's also JDC Murray, who is a little bit of a phantom character. Francis describes him as an old Nassau County lawyer and an asset for Frank Gullotta. He also, along with Dr. Robbins' lawyer brother, directed Dr. Robinson and his brother. So you now have, the multiple puppet strings going on, because he's directly subservient to Frank Gullotta, and Frank Gullotta has to make sure that all these stories line up, so he instructed the brother and Dr. Robbins about the know-nothing story after his first premeditated statement in the courtroom at the DA's office with Fred Vierschning and Francis E. Dec there, which was never admitted into the trial as evidence, by the way, and he was also never called as a witness, which meant that Francis couldn't cross-examine him. Once again, you could have just called him yourself. And finally takes aim at Arthur Nixon, saying he was allowed to finish his statements based on non-existent evidence and witnesses, aka all those people he said he didn't call but produced key evidence like doctors and detectives, and he says this evidence is non-existent because you didn't call the people who did it, and he fights it with precedent. I really don't want this to be a legal video, so I'm gonna skip over precedent unless it's really big precedent, but once again, not a lawyer, so I don't know what big precedent would be. But I just want you to know that he does cite legal cases, and I don't want to get into the legality of this. I mainly just want to get into the summary and what this means to Francis E. Dec the man. Anyway, Arthur Nixon finishes his statement. The judge then reads the indictment of a primarily fabricated story and evidence, but still acknowledges some of Francis's stronger points. Mainly these points being the separation fees and the amount of contact that Elizabeth Vierschning had with Francis. Basically saying, okay, maybe she didn't see him once or twice, and maybe there were some legal fees for separation, but you still, didn't give her consent to do any of this. You didn't get permission. You just did it. And further says, quote, I further charge you that even though the defendant, Francis E. Dec, performed some legal services for Elizabeth Vierschning with respect to a separation action, and by that reason thereof was entitled to some legal fee for such services, that would not justify him in committing the crimes, the charges alleged in the indictment, and his performance of services for the separation action is no defense whatsoever to the counts in the indictment. Gentlemen of the jury, that concludes my instructions. End quote. And then Francis says something that kind of hit me a little bit. I didn't even, because you don't see this in a lot of the shows. Maybe it's not even a thing at all. But he says that this is a charge in name only. Effectively saying they're just throwing the book at me because they want to get me out of their hair and into prison so they can undetectable exterminate me. And that his crime wasn't apparent to a layman. He says the jury was guided to the verdict because that previous quote from Judge Sullivan, the judge gives his opinion in Francis's view. I can't say, I don't really know these type of things. He also says that this jury being guided to the verdict of guilty violates his many legal rights to due process and a fair trial. Remember, third question, keep that in your head. Elizabeth Vierschning was never charged with forgery despite her 2 different injury statements. Dr. Robbins was never charged either, nor Burchell, for their modification of trial records and just lying perjury on the stand, Dr. Robbins. The judge refuses to correct the charge, and Dec takes many exceptions, basically saying, we'll settle this in the appeal, we'll settle this in the appeal, we'll settle this in the appeal, and that the judge is preventing the jury from being the sole judge of all questions of fact in the refusal to correct the charge. Basically saying that my crimes aren't apparent to a layman, you're guiding them to a verdict, and by you not correcting these charges to be apparent to a layman is preventing the jury from being the sole judge of all questions, which is a big thing in legal trials. The judge isn't supposed to do anything. They're a non-partial arbiter. They're like the game master. They're not supposed to have any direct hand in the world, Gary Gygax, but this is why he appeals for a mistrial. He basically says, due to the judge's actions and all these other previously mentioned things, the alteration of the documents, me not being able to cross-examine all these people who brought in key evidence, and my crime not being apparent to a layman, and the judge overtaking the jury, someone who's supposed to be non-partial becoming partial, I request an appeal on the grounds of a mistrial. Now, we get to a more current period in our timeline. Defendants post-trial and appeal motions. This is the next section. He made an appeal, starting off, to the Second Division of the Appellate Court, Supreme Court of New York State, compelling stenographers to produce the trial records. And due to a failure to respond by the DA, it was delayed a month and a half until a third court stenographer delivered a trial record and had his appeal rejected. Now, I have a quote here that literally made my jaw hang open. I will read it. Quote, on October 5th, 1959, the defendant made application to the county court, Nassau County Court, to amend the trial record. Defendant, Francis E Dec, submitted 794 proposed amendments, 320 typewritten pages in length to the Nassau County Court. Said amendments substantially corrected the fraudulently altered trial minutes. End quote. Can you believe such a thing? On top of writing these 2 appeal briefs, after getting his appeal rejected and having the court stenographer deliver the minutes, he arduously goes over it, and by the way, in a 992-page document, adds or proposed to add 320 more pages. Do you know how many pages that is? That is 1,312 pages. That is more than a good chunk of novels. I think that's more than Atlas Shrugged. Would you rather read Atlas Shrugged 1.125 times, or would you rather read Francis E Dec's trial minutes, but the amended version? You get to pick. Neither is a fun time. I will see you when you're done. Also, small reminder, if you are a lawyer and you feel that these are still obtainable, I would love to talk to you about a consultation about such things, because I don't have the time, probably not the money either. I would be acting in forma pauperis, but I'll try my best. I will try my best to compensate you for your services. Please, if you are a lawyer, please talk to me about retrieving these documents from the pits of Nassau County Court archives. They've got to be in there somewhere, I almost guarantee. Or maybe not, I don't know. I'm just a layman. But once again, email's in my about page or on screen, occultwormspeaker@gmail.com. Anyway, enough begging for legal services on the internet in a public video that probably 10 people will watch. After this, of course, the court refused to accept them. He then accuses the stenographer who brought him the notes, his name is Michael Woke, aka WOWK, of him also altering the trial record and Judge William Sullivan being fixed, as well as the jury, to scapegoat Francis and cover the rear ends of the corrupt lawyers mentioned in the brief. You know, Frank Gullotta, J.D.C. Murray, Robbins' lawyer brother, some of which who would become Supreme Court justices after, or New York State Supreme Court justices afterward. What has he got against court stenographers, man? They just record down what you say. Like, even nowadays, we have recording. I mean, like, why even need a court stenographer? You can just verify exactly what the record says if it's different, dude. losing my mind already. Francis says many of these excerpts that would prove Judge Sullivan and Prosecutor Nixon have been culled from the record laboriously. These testimonies and the complete faltering and breaking down of chief witnesses because Dec was so expertly manipulating them into confessing that he was right the whole time. These were all laboriously cut from the extant records of the trial minutes. And he uses this a lot. Some of the almost continuous, wanton, frantic, impish efforts of judge and prosecutor undertaken in concert are still extant in the said record of the extremely long trial, aka they laboriously culled the worst of it, but they're still laughing at me because some of them are still in there, and you can see it. Can't you see that these people are making me out to be a fool? And substantial examples were extracted from the trial minutes, and the judges and prosecutors' wanton, frantic, fanatic, kangaroo court style of stifling of the breakdown confessions of the completely faltering perjurous chief witnesses, namely Elizabeth Virschning, Dr. Milton E. Robbins, and especially the perverted, notorious, felonious car thief Fred Virschning, wayward husband of Mrs. Virschning, were not incorporated in defendant's appeal brief. Examples of these wanton actions by judge and prosecutor are included below. The first example is an excerpt from direct examination. He then also calls Arthur Nixon frantic much further and goes on to say, quote, "The chief henchmen of the defendant's persecution through illegal prosecution, such as Frank Gullotta, Edward Robinson Jr., presently both Supreme Court judges, and Manuel Levine, District Attorney of Nassau County, are above the law. They so wantonly create and administer the falseness of defendant's indictment and the falseness of the prosecution's witnesses, complaining statements, and perjurous testimony are not only known to those men such as Frank Gullotta, Edward Robinson Jr., and Manuel Levine, and other important members of the judiciary, but in addition, they said perjuries and falsehoods were frantically and fanatically, fraudulently created by and for these men. For me to overlook these wantonly impish, lawless actions of these men and other men mentioned in my lower court appeal brief would not only be the undermining of my appeal rights, but more important, it would be a tacit resignation to the perpetuation of such wantonly impish, lawless actions by important members of the judiciary. The aforementioned setting aside of the processes of law and order by such men as Frank Gullotta, Edward Robinson Jr., and Manuel Levine, and their Gestapo-like persecution of this defendant through illegal prosecution resolves our entire constitutional form of democratic government into a facade for a dynamic, labyrinthical, omnipotent, lawless, judicial dictatorship. Conclusion: the judgment appealed from should be reversed and the indictment dismissed. Respectfully submitted, Francis E Dec. Unquote. That is his appeal brief. This is what he submitted to the State of New York Supreme Court, Second Appellate Division. Frankly, you can kind of see where he's coming from, because if I didn't post it earlier in the card, it's also here in the card, I would go at least listen to one of them. Pick your favorite. But this is a proto style of his classic schizophrenic ranting. This kind of proves that he was pre-schizophrenic, at least latently, throughout most of his observed life. And I just need you to remember, where is he coming at this from? How does the computer god play into all of this? Is this a fair trial? You might be able to get some inklings. Personally, I don't want to sway you in one way or the other. You, as the jury of public opinion, will decide for yourselves, but I, like Judge Sullivan, will give my recommendation at the end. But we are given a rare blessing in Francis's stories. We are given a reply by Nassau County themselves. And this is where we can glean most of what really happened, quote unquote. And when I say most of what really happened, I mean the state's story. This is effectively going to be what I believe is most definitely what happened, because this is after they've ironed out the details. But I am going to read in full. I'm going to put a timestamp if you want to skip it, but just know that this is most likely what happened, and that this being the skeleton, we can put the muscle, bones, and fat around the rest once this is read. But if you have no interest, I suppose, in listening to what really happened, and you just want to continue with the insanity, go to the timestamp that I've posted on the screen to continue with the analysis of Nassau County effectively ripping Dec to shreds in the politest way possible. In the section titled The Evidence, it goes, quote, Just a small editor's note before I read the evidence. It's at this point that I have now finally drank, I believe, 1 U.S. quart of water while recording this, because I have a mug from Pennzoil that has 1 quart of water size, because it's supposed to be like a little oil can, and the word count was a little disingenuous because I didn't put the entirety of the evidence. It just says Nassau County's reply, aka what really happened, read the evidence. Okay, anyway, start the quote. The evidence, the people's case. Elizabeth Virschning, involved in an automobile accident in Westbury, New York, on January 9th, 1956, retained the appellant, aka Francis E Dec. Whenever I say the appellant, I'm meaning Francis E Dec. That day, for her claim against the operator of the other car. Mrs. Virschning was neither hospitalized for her injuries, nor treated, nor examined by any other physician other than her family doctor, Dr. Azara, and a doctor for the insurance company. She was never treated, nor examined by a Dr. Milton E. Robbins. After retaining the appellant as her attorney, she only saw him once again, sometime in February of 1956. However, a few months later, she telephoned the appellant about a possible separation action against her husband. The appellant declined to handle such action and referred Miss Virschning to, quote, another lawyer, unquote. Mrs. Virschning never received any money for the injuries she sustained in the accident. At all times since the accident, she lived at the same address and had a telephone. She telephoned the appellant, quote, quite a few times, unquote, in 1956 and 1957, as to the status of her claim. But the appellant told her it was a, quote, nuisance claim, unquote, and he had never disclosed that it had been settled. The signature on a general release, People's Exhibit 2, was never signed by her, nor had she authorized anybody to sign it for her. In fact, the letter C was omitted from the handwritten signature of her last name, which appeared on this instrument. She never appeared before the appellant to acknowledge that she had signed this general release, nor did she authorize her husband to sign on her behalf. Similarly, she had never endorsed nor signed in any manner her name on a settlement check in the sum of $400, People Exhibit 4. In fact, she had never known prior to June 1957 that her claim had been settled. On cross-examination, Mrs. Virschning insisted that she only visited Dr. Azara on approximately 4 occasions for treatment of her wrist injury. The appellant, together with her husband and her child, accompanied her to the physical examination conducted by the insurance carrier's physician. She didn't remember whether or not she told the physician for the insurance carrier of visits to her family doctor or of injuries other than those she had described on her direct examination. She had, quote, probably made mistakes in spelling her new married name, unquote, at first. Her name had not been misspelled on any of the 5 places it had been typewritten on the general release. She could have left out the letter C when she signed her name when first married. The handwritten endorsement of Mrs. Virschning's signature on the settlement check bore the middle initial A, but this initial did not appear on the face of the check. Mrs. Virschning had not been treated for any nervous condition, nor was she receiving in any sedation. At the time, she consulted the appellant with reference to a possible separation from her husband. On redirect examination, Mrs. Virschning again testified she had never signed either People's Exhibit Number 2, the general release, nor endorsed People's Exhibit 3, the check, nor had she received any money whatsoever as a result of the accident. Frederick P. Virschning retained the appellant on January 9th, 1956 in connection with the accident earlier that day. He took his wife to Dr. Azara on 4 or 5 occasions. He never took his wife to a Dr. Milton Robbins, nor had ever heard of Dr. Robbins until May of 1957. He had not signed his wife's name to People's Exhibit Number 2, the general release, nor ever authorized the appellant to do so. He had not endorsed his wife's name on the People's Exhibit Number 3, the check, nor ever authorized the appellant to do so. He did not receive any money as a result of the accident. Mr. Virschning telephoned the appellant, quote, a few times, unquote, and went to his office in 1956 and 1957 concerning the status of the case. The appellant never revealed that the case had been settled or that the $400 had been received in November of 1956. On cross-examination, Mr. Virschning admitted that he had not been informed by his wife that she had consulted the appellant in a separation action. Mr. Virschning also consulted the appellant about income tax matters And as to a claim for property damage to his automobile, he did not remember whether he had given the appealant a paid bill for $160 for repairs to his car. Mr. Vierschning never received any bill or statement from the appealant for services rendered to Mrs. Vierschning in connection with the proposed separation, nor any letter from the appealant concerning the separation. Nathan Burchill, Nassau County Court reporter, testified that People's Exhibits number 5 and 6 were true, and correct transcripts of the question and answer statements made by the appellant to Assistant District Attorney Edward Robinson on July 2nd and July 22nd, 1957. Dr. Milton E. Robbins testified that the appellant prior to July 5th, 1957, had referred accident cases to him. On July 5th, 1957, the appellant requested Dr. Robbins to copy, quote, in his own handwriting, a typewritten bill on, quote, on a Mrs. Vierschning, unquote. Dr. Robbins did so even though he had never seen a Mrs. Vierschning, nor treated her, nor x-rayed her. On July 8th, 1957, the appellant visited Dr. Robbins and told him that he, quote, decided to retain some money in this particular case. The appellant told Robbins that he, the appellant, had made out a false bill because, quote, I had to get the money, unquote. When Dr. Robbins, quote, became panic-stricken, unquote, as to the possible consequences of the false bill, he acquiesced in the appellant's suggestion to destroy all of the doctor's x-rays to conceal the fact that he had never x-rayed Mrs. Vierschning. He delivered several hundred x-rays to the appellant after consulting his brother-in-law and attorney. Dr. Robbins told the full facts in the appellant's presence to Assistant District Attorney Edward Robinson. Dr. Robbins had not signed or written the bill for alleged services rendered to Mrs. Vierschning, which was submitted to the insurance company, People's Exhibit number 9, and had never seen Mrs. Vierschning at all prior to the trial. On cross-examination, Dr. Robbins testified that he made out the bill for the alleged professional services to Mrs. Vierschning, quote, as a favor to the appellant, unquote, but had never done so for any other lawyer. He reiterated that he made out the bill on July 5th, 1957, a year and a half after the time when the alleged services had been rendered, but that he kept no records of his bills that he had made. He had never received any money for those alleged services, even though he marked the bill paid. Dr. Robbins admitted that he had previously lied to the district attorney, but told the truth after consulting 2 lawyers. Joseph Rubaka, operator of a garbage truck, testified that the appellant asked him on July 8, 1957, to take some x-rays from the appellant. The appellant paid him $1 for carting them away. Charles Martino, who had been employed as a claim examiner by the Allstate Insurance Company, kept the files of all claims against the company, which were handled by him. He worked on the file until it was settled of Mrs. Vierschning's claim against one of the companies insured. On September 24th, 1956, the appellant telephoned Martino and told Martino that he had a $48 medical bill for Mrs. Vierschning. The amount on the medical bill was a material consideration in Martino's offer to settle the claim for $400. On October 26, 1956, the appellant forwarded to Martino 4 general releases and some medical bills with a covering letter. After receipt of these documents, Martino ascertained that the general release was properly acknowledged and relied on the genuineness of the signature on the release before authorizing payment of the settlement. Martino would not have issued the settlement check for $400 if he knew that Dr. Robbins' bill was false. On cross-examination, Martino testified that the report made by the physician for the insurance carrier showed that there were, quote, no objective findings, unquote, of the claimed injuries sustained by Mrs. Vierschning, but that Mrs. Vierschning's claimed to this doctor she suffered bursitis of the right shoulder and bruises of the right thigh. Moreover, the doctor's report did not indicate that Mrs. Vierschning made any complaint of a wrist injury. As the report made by the physician for the insurance carrier revealed no objective findings, Martino relied more than usually on the doctor's bill submitted by the appellant as to the facts of the claimed injuries. Russell K. Casey, claim manager for the Allstate Insurance Company, had custody and control of all claims filed in the Flushing office during 1956. The file involving the claim made by Mrs. Vierschning remained in the custody of the Allstate Insurance Company until it was turned over to the district attorney in 1957. George W. Young, the treasurer of the Island Savings and Loan Association in Hempstead, New York, testified that People's Exhibit number 3, the settlement check, was cashed at his bank in November 14th, 1956. He had compared the endorsement of the appellant's name with the appellant's signature on file with the bank, and it was his opinion that the appellant personally endorsed the check. George E. Vincent, in charge of the notary department in the Nassau County Clerk's office, testified that the records of his office showed the appellant was qualified as a notary public during the years 1956 and 1957. Russell F. Scott, a detective of the Nassau County Police Department, was qualified as an expert in questioned documents. He gave as his opinion that Mrs. Vierschning did not write the signatures which appeared on either the general release or the settlement check. Moreover, it was his opinion that Frederick Vierschning had not written his wife's signature on either the general release or the endorsement on the settlement check. The appellant conceded that Dr. Robbins had not signed the medical bill for the alleged services rendered Mrs. Vierschning, which was sent to the insurance company. End quote. They butchered him. It even goes farther to keep with the massive quote. The next section is titled Point 1, quote, guilt was established beyond a reasonable doubt. Evidence of the defendant's guilt was overwhelming, unquote. And this section just generally goes over everything that proves the charges and the defendant's inability to refute. It was also a unanimous conviction. He really does not have a lot to stand on. Just the amount of citations I had to skip over. They cited the trial documents so many other times. They had physical evidence. They had overlapping witnesses. They brought in people Francis didn't even mention. They even talked to the garbage guy. He's like, yeah, I got $1, which is like the equivalent of like a 20. Like, here you go. Here's a 20. Can you carry off these x-rays for me? If you believe the state, Elizabeth Vierschning never visited a Dr. Milton E. Robbins, never signed the check. And George E. Vincent, the guy who was in charge of the notary department, said, yep, this guy's a notary public. And the guy at the bank said, yep, this guy cast a check. And Martino was apparently the adjuster. I have no idea where this Mr. Urso came from, but it sounds like Martino was the one who negotiated this. And Russell Casey, the claim manager, sounds like he had approved it. And of course he's like, oh, was it? If I had known it was fake, I wouldn't have approved it because, you know, that's company policy. We don't like just hand out free money to people. I think the only thing that might have gone in Francis's favor was that he's like, yeah, I was, you know, consulting this woman about separation action. But, you know, that's not really relevant in the cosmic sense of, you know, he's nitpicking things that don't matter. He's saying, oh, these witnesses and... I mean, what? Guilt was beyond a reasonable doubt. Listening to that, or just listening to his previous stuff, and then reading this from the state. Did he get a fair trial? You have to ask yourself, what did he do? What's his angle? What's he trying to do? Obviously, he's trying to get out of this with something. Probably still his job or not get disbarred because that's usually what lawyers are going for in minimum. You know, they can pay money. They're lawyers. All of them are lawyers. They're all billionaires or whatever. But like, what's his angle? Because it's such a personal one. And I know I'm teasing you, but I thought it was interesting. I gotta finish this tonight. Okay. Point 2. The defendant received a fair trial. Here's the state's answer to the question, did Francis E. Dec receive a fair trial? First of all, they go over everything in evidence the evidence, and they go page by page in his brief, and they're like, this is wrong, this is wrong, this is wrong. They just dismantle his previous appeal brief page by page. It goes over the proper dismissal of the indictment, that thing I told you before, where he filed it in the wrong court and the other one was filed as a demurrer, which could basically be dismissed offhand. And they also say the jury was unanimous. There was literally not a single person who voted for you. And they are the prime deciders, not the prosecutor, not the judge, not any of these other people in the courtroom with you, not Dr. Robbins, who you've kind of just pulled into the story for no reason, honestly. And they say the jury decided your fate, not the court. And I just love it because they kind of sink to Dec's level. I don't want to say that because they're actually still trying to say it in the nicest way possible. They're not saying everything's rigged. We did it. You'll never do anything about it, you stupid lawyer. Just to give you kind of an attitude of how this reads, here's a small quote. It proceeds as such. Quote, apparently, the first claim of error appears on page 21 if the appellant's, Francis E. Dec's, brief, wherein the defendant, also Francis E. Dec, contends there was an abuse of discretion by the trial judge whereby defendant was prevented from a thorough cross-examination of some of the people's witnesses, then cites the defendant's brief. The trial record consists of 991 pages, most of which was taken up by cross-examination. There is absolutely no proof that this defendant was deprived of a fair trial because of any ruling by the trial judge in relation to cross-examination. Cross-examination in this connection related largely to secondary matters, and consequently, the extent of the cross-examination was largely a matter of discretion for the trial judge. They then cite People versus Ramstella, a case from 1954. In particular, the defendant claims that he was prevented a full opportunity to cross-examine his former client, Elizabeth Vierschning. The evidence shows that Mrs. Vierschning's direct examination ran from pages 33 of the record to 63, whereas the cross-examination ran from pages 63 to 249. It could hardly be said that the defendant was prevented from cross-examination. Defendant then discusses the testimony of Dr. Robbins, cites the defendant's brief, with no apparent reason. Nowhere during this discussion does he demonstrate that he was deprived of a fair trial. End quote. Stop, he's already dead. Then, an actually positive thing for the state to do, they go to bat for Nat Burchell. Remember how I said he's a veteran stenographer, about 30 years? And they also say, you know, we're kind of misunderstanding where the mistrial plea is coming from, because this guy transcribed literally every case in Nassau County until his retirement. And they then say, quote, "The unwarranted and unsupported attack on the integrity and reputation of Mr. Burchell as revealed by this record was not justifiable. The trial adjournment was due to it being adjourned Thursday. Friday was unavailable due to court business. Tuesday was an official holiday, so it was adjourned till Wednesday." This is them talking about that, 2 days after the trial started, they adjourned it for no reason, and it was just to alter all these documents to make me look bad. They said, well, actually, you attacking Burchell is a complete lie, and we have no idea where you're coming from. And second of all, we adjourned the court Thursday. The court had other business on Friday. They're obviously not going to work weekends. Why do Monday when you're going to have to adjourn for Tuesday being an official holiday and then resume Wednesday? We'll just go to Wednesday. They effectively say this is not malicious. This is just effective court procedure. And there is absolutely no evidence showing that there was an abuse or that the adjournment deprived the defendant of a fair trial. The defendant once again turns his attack on Nat Burchell, the official court stenographer, and once again contends that Burchell's stenographic notes should have not been received into evidence, quoting the defendant's brief. The substance of the defendant's claim, once again citing the defendant's brief, is that Nat Burchell forged or altered the transcript of the examination of the defendant, conducted by the Assistant District Attorney Edward Robinson. Burchell denied that he altered the minutes and that there was absolutely not one scintilla of evidence to controvert this evidence except the unsupported and uncorroborated testimony of the defendant himself, unquote. They're basically giving him the super polite version of, what the hell are you talking about? They also then go on to say, it's not the stenographer's fault that you said incriminating stuff during the trial. They just record that down, and albeit it's not a confession, you did some real damage to your case by saying this. And they also say the thing that I've been saying this entire time. They then say, oh, well, if you wanted to bring any of these witnesses, you could have called them yourself, but you didn't, did you? That's not our fault. That's your fault. Because you're not taking any blame in this. They don't say it directly, but that's the exact vibe they give. They give, you're not taking any responsibility, and we're not certainly taking it all. They then say, in the next section called The Charge, which is, they say, you're charged with 2 counts of forgery, 1 count of grand larceny, and Dec previously making a plea for good character, basically saying, everyone knows that I'm a good guy. Like, everyone knows, like, I'm the lawyer. Like, I'm Mr. Lawyer. I've been, like, a big fan in, you know, the Polish community. Everybody knows me. They come to me for all their claims. I'm, like, a super good guy. And then they say, if you wanted that to be considered, you gotta testify and also bring forth witnesses, which you didn't, to testify to your good character. Because they then go on to further eviscerate him, saying, quote, in a similar vein, the defendant also contends that the trial court committed prejudicial error in failing to charge as to the bad character of the people's witnesses. The people must respectfully submit the trial record reveals a slanderous attempt by this appellant, Francis E Dec, to destroy by innuendo and suggestion Mrs. Vierschning and everyone else connected with the trial or the investigation. The outrageous claims made by this defendant regarding the reputation or character of the Virschnings or the public officials are unsupported and without any basis in fact. There is not one scintilla of evidence available to prove the bad character of the Virschnings or any other witness who testified against the accused. Basically, once again, the polite version of, Francis, what the hell are you talking about? Because you're not it might have come out in the appeal brief, but he doesn't support any of this at all. He just says it, and he thinks that people will just take him at his word because he's the Francis E Dec. He's like Mr. Francis E Dec, Mr. Lawyer Guy. Because obviously he has a good reputation, and he's not known for being some schizophrenic ambulance chaser. No, that's false. That would be depriving me of my right to the fair trial. Then they can't leave him even one more I'm losing my voice. It's going. It's 4:05 in the morning. I've been recording for 4 hours. And I'm not even halfway done. Oh. They can't even leave him. Anyway, they can't even leave him with one tiny little scintilla, in their own words, of evidence that he was deprived of a fair trial. Because remember, if they're denying him his appeal, there can be no room for errors, so they have to address literally every single tiny little thing that he says. They then state that the jury wasn't fixed or ruled improperly. They say, quote, finally, the defendant contends that the record of the trial was fraudulently altered by the court reporter, who in this instance is Michael Wauch, and that his conviction was brought about by a vicious conspiracy including District Attorney Frank Gulata and the Chief Assistant Edward Robinson, both of whom were paid off with a Supreme Court judgeship. There is no support in the proof for these allegations. The defendant had a fair trial. The trial judge gave the accused what amounted to almost unlimited leeway in conducting his trial. His contentions were fairly presented to the jury, and the issue of fact has been clearly and fairly resolved against him. In conclusion, the judgments appealed from should be reaffirmed. Respectfully submitted, Manuel W. Levine, District Attorney, Nassau County. Attorney for the respondent, Henry P. Devine, Assistant District Attorney of Counsel. End quote. I mean, what do you even say? They addressed systematically, citing physical evidence, citing testimony, citing all the other good things you'd want, especially, once again, I didn't even realize that I pulled that out of this, unlimited leeway in conducting his trial. Remember how I said that that's generally what people do when they're trying to make people not appeal? They give you unlimited leeway to make whatever mistakes and do whatever you want, so that when they finally dress you down and nail you to the wall, they will never ever let you go. I feel like that's what this conveys. And just to kind of end it off on, not with a roar, but with a whimper, Dec has a response to Nassau County's response. And it's a whimper, not a bang. He seems like this response had basically emasculated him, because this fits on 2 pages. 2. He basically reiterates all his key points, almost in fact ignoring the Nassau County appeal response, but it's not enough. He just repeats all his points with less zeal. He nitpicks all these minor things that don't matter, mainly about saying like, oh, these things you say I don't have any evidence, but look, I have all this evidence that doesn't exist because you guys removed it from the court record. That's crazy. How am I supposed to fight my case if you guys will just nitpick and destroy everything in the court record that would support my case when you guys were in fact supporting it from the very start? How am I supposed to do that? He also really does nitpick the stenographer's notes are a confession, and you can't consider this a confession because of all these reasons, and I'm going to cite all this precedent, even though they never said it was a confession, and he's like, it has to be voluntary, and it was, he said it, the stenographer wouldn't have recorded it down if he didn't say it. Oh yeah, the stenographer's a mind reader, he's one of those psychic vampires who can read people's thoughts, and he's just writing down what Francis is thinking, and he didn't actually say that. But he basically just says, please give me my appeal. And even I can see that it won't work. It's not good. It definitely isn't strong. If you considered his first one flimsy, that one's like a piece of paper. This one's like a torn up piece of wet tissue paper. You could just blow through it without anything else. So where does that leave Francis E Dec? Well, I can tell you it doesn't leave him in a very good spot. he has exhausted one of his two options. Now, let me give you a question, Batman. I don't know why I'm doing a Riddler impression. This isn't even a riddle. What would you do if you were rejected an appeal in a lower court? What would you do? This is over about $5,000, and you yourself are a lawyer. You have nothing to lose, well, except your lawyer title, so I guess what would you do? The answer that Francis E Dec came upon is to go to the Supreme Court. He's gonna go to the Supreme Court and to the highest court in the land, say that he deserves an appeal all the way up to the Supreme Court because he has been deprived of all of these things. And let me tell you, the Supreme Court brief is even longer than the one to the Nassau County Court, and this one was written first, by the way. So when you acknowledge the language and stuff written here, just know that this was written first, and then he decided to transition his style, or maybe mute it a little bit, or maybe he took his meds. But this is what he leads with. And just to break the illusion a little, I gotta stop for today. This is gonna be a 2-day recording. It's like 4:12 in the morning. I've been recording for like 4, maybe 4.5 hours. Oh boy, I'm not even halfway done. Oh. Anyway, I'll see you tomorrow. Deal with this mess tomorrow, if you can. Well, I'm back tomorrow, and we'll see if I can deal with this mess. What did I promise you yesterday? Oh yeah, Supreme Court stuff. So, his first document that he files is one called Informal Pauperius, which is Latin for in the character or manner of a pauper. And this is where it also gets another little bit of insight into what Francis is dealing with, because this is effectively him asking to proceed with the Supreme Court proposal for free. And what this means is he's asking to proceed in the manner of a pauper, meaning he's waiving a lot of legal fees for legal representation. He's waiving a lot of fees to gain judicial documents, and he's appealing, and allegedly he states the reason that he has no money because he's filing this 3 years afterwards, and he's allegedly been in prison. This is where he says, like, I've been in prison and I haven't been able to make money, and this is effectively his sworn and notarized affidavit to the Supreme Court that what he's seeking is a valid thing to seek. And he primes the Supreme Court with 9 questions, which is way more than I gave in the beginning, so you only need to absorb these in the sense of they're going to be relevant to the Supreme Court brief. But the questions are as follows, quote, 1. May a state, consistent with the due process of law, guaranteed by the 14th Amendment, to which guarantee is pertinent the right to a speedy trial, repeatedly adjourn a citizen's criminal trial over a period of 9 months in spite of the citizen's duly undertaken repeated demands for a speedy trial as guaranteed by the Constitution, unquote. This one basically says, are you allowed to adjourn the trial for all of these times and delay me the amount of times that you did? Because I don't think that's kosher. Question 2. Quote, may a state consistent with the equal protection and due process of the law guaranteed by the 14th Amendment deprive a citizen of his statutory right to appellate review by producing a substantially fraudulently altered official trial record, which said trial record is obviously, wantonly, fraudulently deleted, abbreviated, juxtapositioned, hashed together, jumbled, and lengthened with substitute material in an obvious attempt to keep secret the Gestapo-like farce kangaroo court trial to support an unjust, felonious conviction of the citizen, a volunteer veteran of World War II, and a member of the bar of the state of New York, unquote. There's a lot to unpack in this one, but it effectively simplifies down to, are they allowed to convict him on a altered court record? And because he's such a good guy, he served in World War II, although he never saw combat, he was in training the whole time, and he was also a member of the New York State Bar. Are you allowed to deprive him of his honor and dignity by giving him this Gestapo-like farce trial? I think we're far enough into the video that I can just say that. But anyway, question 3, quote, may a state consistent with the equal protection and due process of the law guaranteed by the 14th Amendment, uphold the felonious conviction of a citizen brought about through the halting of the cross-examination of the completely breaking down and confessing perjurious chief prosecution witness, Mrs. Elizabeth Virschning, wherein, through her sworn detailed cross-examination testimony, disproved the accusations of the false indictment created by and through the Gestapo-like frauds of the district attorney and his staff, and the trial's courts further ordering the alteration of said Elizabeth Wiersting's cross-examination, and with that of the near non-existent hearsay testimony of the near speechless, petrified, aged, perjurist, lifelong district attorney stenographer, namely Nathan Burchell. And after halting both said cross-examinations in spite of the citizens' objections, the court ordered the halting of the citizens' trial for approximately 1 week, during which week the citizen defendant was coerced through oral and written messages by Judge Philip Kleinfeld, a judge of the New York State Appellate Division of the Supreme Court for the Second Judicial Department. The said messages warning the citizen defendant that, regardless of the citizen's innocence, the citizen must surrender his constitutional rights as a citizen and lawyer and give up trying his own case because both judge and jury were fixed. And if the citizen did not retain a quote-unquote chosen ex-district attorney, namely Edward Neary, as his lawyer to plead guilty to the false charges, then the citizen's trial would lead only to a citizen's felonious conviction and a severe prison sentence because, quote, the judge and jury are fixed, unquote, unquote. That's a long one. But it effectively kind of overlaps with the first one, you know. Trial records altered. Nat Burchell is obviously altering this said record. And is a judge allowed to intimidate me into accepting the fixed outcome because, you know, he hates district attorneys? So, we want you to take on this ex-district attorney as your lawyer. And he laughs and he says, it's rigged, it's rigged. They advised me to take on a really good lawyer because everyone's rigged against me. Oh, man. It won't go your way if you represent yourself, Francis, probably because he's a terrible lawyer. Anyway, question number 4. May a state consistent with the equal protection and due process of law guaranteed by the 14th Amendment uphold a felonious conviction wherein the trial court, in collusion with the prosecution and in spite of the citizen defendant's objections, withheld the contradictory sworn statements of compliant of the prosecution's perjurous only 2 chief witnesses, namely Mrs. Elizabeth Wiersting and Dr. Milton E. Robbins, especially when withheld statements disprove the indictment of the citizen defendant, unquote. Basically saying, when are you going to accept my amendments? If you accept my amendments, is the state allowed to withhold accepting my amendments? Because if so, rigged. It's getting to me. It's getting to me. Number 5, quote, may a state consistent with the due process of law guaranteed by the 14th Amendment uphold a felonious conviction of a citizen brought about by a trial wherein repeated statements by the trial judge and prosecutor claim directly and impliedly and through statutory definition that a hearsay unverifiable copy of the district attorney's stenographic notes consisting mostly of hearsay conversations of others than the citizen defendant, did constitute a confession by the citizen defendant and thereby, through statutory definition of criminal confessions, practically convict the citizen defendant when subsequently, through written admissions of the prosecution in the prosecution's appeal brief to the Court of Appeals of the State of New York, the said district attorney's hearsay stenographic notes are stated not to constitute a confession, a contention obviously directly opposite to that taken by the prosecution and trial judge during the citizen's trial, unquote. So he's kind of accusing Arthur Nixon of being two-faced. He's saying, you know, they said that this was a confession in court, and now they're claiming that it's not a confession. Like, which one is it? Pick one. You gotta pick one. We're almost... He mentions the 14th Amendment a lot. What is the 14th Amendment again, just for reference and possibly non-American? The 14th Amendment. Oh yeah, this is the equal rights one. Grants citizenship to all persons born or naturalized in the United States and protects their rights to due process, equal protection, and representation under the law. Gee, sure sounds like he's getting equal representation under the law, right? Remember, is his trial fair? I don't know, he's making it not seem very fair. Number 6, quote, may a state consistent with the right to due process of law guaranteed by the 14th Amendment place in evidence and permit the prosecution to repeatedly read aloud to the jury during the citizen's criminal trial copies of stenographic records of conversations of people other than the citizen who were never made witnesses during the citizen's trial, although they were available, and 2 of whom were important members of the judiciary, especially when the district attorney's stenographer testified that the original stenographic records produced by the said district attorney's stenographer were written in his own personal secret code of shorthand, which can be read and understood only by himself. And, in spite of the citizens' repeated objections, the trial judge precluded any inspection of the said original stenographic notes and ordered the citizen to accept the veracity of the district attorney's stenographer's stenographic notes on the say-so of the district attorney's stenographer. And further, the said hearsay stenographic notes were falsely stressed by the trial judge in collusion with the prosecution as a confession by the citizen in that said citizen's criminal trial that brought about the felonious conviction of the citizen. Unquote. Simply, he's then taken the stenographer's side of this, saying he can't back this up. The stenographer is giving evidence that only he says so, but also this is key evidence. Why were these people not brought in as witnesses? Even though I could have called them at any time. Why were they not witnesses? Why did the prosecution not bring them forth? Probably because it didn't benefit their case. That's why you would call witnesses. I don't see a single time in any of these documents where you would call a witness. Although that may change because I don't have the actual trial notes, the 991 pages. Once again, I would love to find them, but... Number 7, okay, this one's at least a little shorter. Quote, may a state consistent with the right to equal protection and due process under the law guaranteed by the 14th Amendment procure a felonious criminal conviction against a citizen through fraud and collusion of the trial court in conspiracy with the prosecution. AKA, the judge and the prosecutor are working together, and... source? But I mean, I guess it fits with the story. Number 8, quote, may a state consistent with the right to equal protection and due process of law guaranteed by the 14th Amendment deprive a citizen of liberty and property through a felonious conviction and intentionally ignore the explicit statutory protection afforded by Section 456 of the Code of Criminal Procedure for New York State, which said section provides that the trial record upon conviction shall be produced within the maximum time of 12 days after notice of appeal has been served, and further intentionally disregard the said statutory rights in spite of the citizen's formal written appellate court motion for an order compelling the trial court stenographers to produce the trial record in accordance with said section 456 of the Code of Criminal Procedure in order to minimize the time in which court officials would have to fraudulently alter said citizen's trial record, wherein support of said motion detailed sworn facts of other felonious fraudulent alterations of such trial records by jurists was stressed by the citizen. Unquote. This one he's saying, why did it take so long to get me the trial notes after I appealed? This is just to get rid of all the stuff that they said that was totally going to convict them if it were in the trial record. But of course, I'm not allowed to get access to these notes because I'm just being discriminated against because I'm a Polish guy. But we'll get to that in a second. And he says the reason why they took so long is because it took them all that time to eliminate it. And if they had 12 days, they would have only been able to get some of it, and I would have been able to pry out the little bits of information that support my story. But at last, number 9, quote, may a state consistent with the right to equal protection and due process of law guaranteed by the 14th Amendment repeatedly coerce a citizen lawyer to surrender his constitutional right to defend himself by coercive statements of state court judges and court officials to the extent that the state's court of appeals did detail letters wantonly with prejudice prejudge the criminal appeal taken by the citizen pro se, and the said clerk of the Court of Appeals impliedly completely approved and sanctioned the wanton, fraudulently altered, almost unintelligible official record of this citizen's trial produced by the lower courts, in collusive conspiracy with the district attorney's office, which said frauds this citizen repeatedly complained of in his appeal brief. Unquote. This one also said, this one's more talking about Judge Philip Kleinfeld. Remember when he was like, this guy specifically is telling me to team up with the DA. Otherwise, you know, there's a bunch of people who don't like me in the state and they're trying to get me convicted and sent to jail. That's what this question is talking about. He's more like, is this judge allowed to intimidate me to accept whatever thing that I have to deal with because all of you are conspiring to get me convicted? A maximum conviction, you may say? Call that a segue. Boom. Unironically, if you know him, you probably know him for one of 3 things. 1, the paper called To All Judges. Second of all, the Master Race Frankenstein radio controls. Or C, you know him from this maximum conviction appeal brief. This was written to the Supreme Court. And I don't even know how he made it. Because this was allegedly written before the Nassau County one, and I feel that any response gotten by the Supreme Court by Dec was a little harsh, probably calling out his language, which explains why the Nassau County one is a little more devoid of any like ranty style language. But this one isn't. This one is unbridled, nigh schizophrenic meltdown. And he kind of eases you into it too. Because first, he explains how he's basically laying out a situation. He explains that up to 5 years in prison is definitely not indicative of whatever he was convicted of. But he's currently on probation and disbarred. So this is still after the trial, probably still fresh in his mind. And he then commissions the Supreme Court clerk to make transcripts of all of his requested motions up to this point. And he then presents the 9 questions that I already read out from Informa Papyrus. And I kid you not, he lists out a bunch of stuff. It's all pretrial motions, namely the motion to inspect the grand jury minutes and dismiss the indictment. He wants all of the amendment paperwork done. The motion to extend time to perfect appeal. Effectively everything he's ever filed. It just lists it all out at the beginning of this. I would love to find all this, but I don't think I ever will because these motions are so minor. I don't even know if they keep motions that long. I'm not a member of the legal system. I'm not a wizard. But he also includes constitutional precedent. Because remember, a key question of this is this a fair trial? And after laying out these questions, he then asks, once again citing the 14th Amendment, it says, "Nor shall any state deprive a person of liberty or property without due process of law, nor deny any person within its jurisdiction the equal protection of all laws." And he sets this forth as the central question. That is the 14th Amendment, Section 1, Clause 2. And then, what you've all been waiting for, his statement. Because when you read this statement, you immediately get drawn back. You get drawn back all the way. Because he starts purely with accusations. He just starts throwing out shots to whoever's going to catch him. The first one is him saying, "I've been calling out these people for years." He's like, they finally got me on something. They finally found something that they can slant enough to get me on. He says, "It's been a fixed trial from the start. It all started a decade ago when the DA's assistant, Henry H. Mayer, started defrauding his son of his disability checks. He was cashing them, and he only wanted to get his son sent to a mental asylum, and he succeeded." And Dec is just like, "This guy's stealing money from the state. It's basically embezzlement." And he complains so many times that he allegedly starts receiving threats from the current DA assistant when the trial was going on, Robinson. And this is so prolific that they also talk about it during the grand jury hearing, which apparently never happened or happened in secret when Francis wasn't looking and they weren't allowed to look at the minutes because he would have been able to alter them otherwise. And he also takes some shots at Arthur Nixon, saying things like, quote, "The many innumerable written public records proving the said illegal prosecution of this defendant cannot all be fraudulently altered to confirm the simple false ravings of trial prosecutor Arthur Nixon. That, you bet your bottom dollar, it's a pack o' lies, where's his proof?" Unquote. "The Gestapo mafia-like illegal secret persecution of this defendant was carried on to ruins this defendant in revenge because of this defendant's repeated righteous complaints of omnipotent gangsterism and corruption of the judiciary and the government." Unquote. He also states that someone by the name of Judge Ulgeta discriminated against his civil service exam results and was hassled while applying to be a police officer despite his apparently really good civil examination scores and results on his police training. And he says that this discrimination is because, quote, "someone in Nassau County really doesn't like you," unquote. But I want to take a pause from the insanity for a second because this is 1950s New York City. Like, I think it's understated how much actual mafia activity was going on because he mentions famous gangsters like the Jacobsons who were part of the Kosher Bosher Mafia, which was a really big racket back in that time period before, the police could actually crack down on it. And him being a cop kind of follows because, how do you crack crime? Well, you be a cop or a lawyer. He kind of picked the right profession and he's kind of sticking to it because he says, "Oh, all these righteous complaints of me seeing corruption everywhere." And how many of those are exaggerated? How many of those are real? How many of those are just flat out fabrications? Because it's been a running theme in this story that he perceives things at least accurately. He knows what's going on, he just attributes the wrong reasons to what's behind them. So I just want to give you that little bit of information. Continuing with the document, he was also repeatedly persecuted in the courts and faced discrimination from judges also like Kathleen Kane, because he just starts throwing out random people that you haven't heard before, Walter Hart and Samuel Greason, also accusing them of altering trial documents to make him look bad. Where have I heard that one before? You gotta wonder if this is just what he goes to the second he starts losing, or this is, you know, just a widespread problem in New York City of people always altering trial documents to make this one specific guy look bad, or just to get more convictions. Who knows? If you're a lawyer or a judge, or a court stenographer, have you ever altered trial documents to convict a guy you just really didn't like? You don't have to confess to anything. I'm not a lawyer. I don't care. But I would love to know, especially if you made it this far. You obviously care enough to look at some guy crash and burn in the appeals circuit. He also throws a shot at a Moxie Rigby, who would also become a judge. She also allegedly tried to convince Dec to give up. I then put the mafia-esque persecution of this poor innocent man knows no bounds. Getting back to it, I want to give some more just starts spraying shots everywhere with, quote, "It was notorious habitual felonists such as Charles Martino, William Fitzgerald, Gerald Chirello, and Joseph Amoru, the last mentioned Joseph Amoru, who liked the small pocked-faced assistant district attorney Joseph Hennigan, who, like other assistant district attorneys, sat at or near the prosecution's table during this defendant's trial and sneered at this defendant for hours, as this defendant, as attorney pro se, defended himself against the false 4-count indictment. Defendant knew Joseph Amaru and Joseph Hennigan from college as simple cheats, and defendant told them so in college. These and other habitual felonialists, all state insurance company officers who knew of this defendant and this defendant's absolute refusal to enter into the usual lawyer bribery and fraud conspiracies with them in the settlement of claims against Allstate Insurance Company, who aided and abetted the Gestapo-like search of each of this defendant's few claims against Allstate Insurance Company to the extent of questioning this defendant's clients in detail illegally before and after defendant's claims were settled by Allstate Insurance Company. These felons, all of whom were eventually discharged from Allstate Insurance Company, and their years of habitual felonious crimes defrauding the Allstate Insurance Company, were condoned by law enforcement agencies to the extent that only belatedly one or two of these habitual felons received censures as lawyers or civil disbarment. It was this group of habitual felons that rabble-roused other Allstate Insurance Company officers to complain against this defendant to the Nassau County District Attorney. After singling this defendant out for persecution, instead of the many notorious, habitual, felonious, and fraudulent ambulance-chasing lawyers they know of, including themselves, they did so, in despite of the fact that the Allstate Insurance Company had written records from both Mr. and Mrs. Vierschning, proving that Mr. and Mrs. Vierschning were actual conspiring felonious culprits who falsely claimed that they knew nothing about Mrs. Vierschning's injury claim and never retained the defendant as Mrs. Vierschning's lawyer. These factors, together with a sadistic, lifelong, omnipotent gangster district attorney Franculata, who as head henchman to this defendant's decade-long Gestapo-like secret mafia-type persecution, brought about the false secret mafia-type indictment of this defendant." Unquote. This is where you can extract from his ranting something that might have actually been happening. Remember question 1? What angle is he taking? This one he seems to be taking a justice angle, especially taking out the opportunity to call corruption on people he may see doing these illegal things, which makes me think that he's actually taking the high ground. He's taking a moral high ground, and considering the allegations against Frank Gulata, namely that he's been doling out rewards, quote unquote, as in promotions, raises, other official type benefits that you might have not gotten otherwise in the circuit of Nassau County at this time, especially with high mafia and gangster operation rates, especially Allstate Insurance Company claims just trying to defraud Allstate. You know, insurance fraud was really easy back in the day, apparently. I feel like Dec tried to get into it at the wrong time because his association with Milton Robbins and Milton Robbins already not being the best, doctor, I feel like he tried to get into it at the wrong time and they had to make an example out of him, partially because they didn't like him, and secondly, because it shows that they're purifying their ranks effectively. We got the guy who was doing it all, so you don't need to investigate us any further. But that's just a guess. This is back in the far, far distant past. All the people involved are probably long gone by now. So take it all with a grain of salt. None of these are serious allegations. I'm just trying to piece together a story that is old, and I want to make sure it stays together before it falls apart completely due to lack of evidence and glue. But I want to give you Dec's version of events. And this is going to be a bit of a longer quote, but it's worth it. I tell you it's worth it. Because this is more classic Francis E Dec goes insane to the Supreme Court of the United States. He's saying this to 9 of the most important people in the entire country. He is writing this to 9 people who are basically going to decide whether he stays a lawyer or even gets to hear his case, possibly establish federal precedent. He's saying it to these people, and he writes, quote, "Convulsive, muddled, incoherent, jeering threats of revenge were stated by an assistant district attorney, Edward Robinson Jr., during the 2 suppositive grand jury hearings of July of 1957. In reference to this and other complaints by this defendant, the defendant was ordered to the district attorney's office on July 2nd, 1957 by Edward Robinson Jr., an assistant district attorney. Without reason or justification, the said Edward Robinson Jr. then accused this defendant of ambulance-chasing, fraudulent accident claims, and in simple, convulsive, incoherent conversation, Edward Robinson attempted to accuse defendant based on suppositive knowledge gained from the know-nothing-about-everything Virschnings, that the defendant was operating a fraudulent ambulance-chasing ring on a small scale. The incoherent ravings of Edward Robinson finally enumerated the complaint of Mrs. Virschning and her husband, Fred Virschning, who claimed that they never knew the defendant and only saw the defendant once and never retained the defendant as their lawyer for Mrs. Virschning's injury claims against Allstate Insurance Company, and they never prosecuted or made any injury claims for Mrs. Virschning against the Allstate Insurance Company. In fact, in simple, incoherent ravings, Edward Robinson informed defendant that both Virschnings swore that they knew nothing about the entire injury claim and settlement of it by the Allstate Insurance Company. Therefore, defendant wasn't an ambulance-chasing lawyer. Defendant quelled the screaming, convulsive Edward Robinson, sufficient to the point that the Allstate Insurance Company file of Mrs. Elizabeth Virschning's injury claim on his desk and specifically point out various papers that proved the claims of both Virschnings to be false, and then demanded to be informed of any grand jury hearing on the matter. Edward Robinson Jr., in obvious petrification, convulsive, and in hysterics, attempted to stop the defendant by screaming, "Level with me!" over and over again as he slumped over his desk, perspiring and looking up at the district attorney, Frank Galata. Defendant informed Robinson and Galata that defendant's records and Allstate Insurance Company's records would prove that defendant was retained by Mrs. Virschning as her lawyer for an impending separation action. And because of this fact, the defendant did withdraw from her wayward, perverted husband's loss of services claim of her injury claim. Defendant again informed both Gulata and Robinson of the repeated efforts of Mrs. Virschning's husband through various coercive schemes to obtain his wife's settlement money she deposited with the defendant in escrow, and that recently the defendant put the husband out of his office under threat of arrest, at which time the defendant informed Fred Virschning that he had coerced his wife, possibly through the usual physical abuse of her, into evading the defendant, while he coerced the defendant into giving him the $200 that she left in escrow. Defendant went with Detective Becker to defendant's office. Detective Becker examined Mrs. Virschning's injury claim file and her separation claim file. After defendant took both file envelopes out of the locked filing cabinet, Detective Becker examined the various papers in the 2 files and opened the letter-sized titled envelope containing Mrs. Virschning's $200 escrow money. Detective Becker then took and purloined the defendant's written retainer signed by both Virschnings, and like the simple raving Edward Robinson, accused the defendant of ambulance chasing with a no-good false retainer. Detective Becker refused to give defendant back the written retainer with the Virschnings,
and instead stated that by his purloining, the retainer made it possible for the district attorney to finally bring an end to the lengthy investigation of the quote-unquote dumb Pollock defendant and finally send the quote-unquote dumb Pollock to prison. Thereafter, on July 22nd, 1958, at the district attorney's non-existent grand jury hearing to which the defendant appeared through a legal subpoena by the gangster district attorney, Frank Gulata stood in charge of Edward Robinson, while Detective Becker sat adjacent to defendant. Defendant was informed to forget about complaining as to the accusations of Edward Robinson falsely accusing the defendant of running an ambulance chasing ring of fraudulent accident cases. Defendant was informed that he had no right to object and that the defendant was in the district attorney's office subject to immediate arrest and jailing because Mrs. Vierschning had placed new charges against the defendant. And those new charges placed against the defendant were true because she also swore to these new charges. The convulsive Edward Robinson then stated that the new charges did not include ambulance chasing, but that the defendant negotiated and settled on an injury claim for her of which she knew nothing about. The defendant interrupted the raving Robinson and informed him that his accusations were false because Detective Becker, who was then sitting adjacent to the defendant, had taken the defendant in custody to the defendant's office and had seen the separation file and injury claim file on Mrs. Vierschning with the various papers in both files along with the $200 in escrow money she had deposited with the defendant, and also signed written retainer of Mr. and Mrs. Vierschning. In addition to this, Fred Vierschning, the wayward, perverted, felonious car thief husband of Mrs. Vierschning, had already admitted to the matrimonial troubles of his wife and that he lived with black prostitutes and ran stolen cars down south. During defendant's rapid questioning of Fred Vierschning in the presence of Dr. Robbins, Fred Vierschning further incriminated himself and proved the defendant innocent by breaking down and admitting that after the defendant's repeated requests of him and his wife, Elizabeth Vierschning, to produce Mrs. Vierschning's medical bill from Dr. E. Robbins, her claimed doctor, for her claimed doctor-treated injuries, consulting her injury claim against Allstate Insurance Company, Fred Vierschning gazed at Dr. Robbins in the district attorney's office, admitted that he, Fred Vierschning, did go to Dr. Milton E. Robbins' office and did obtain and did pay for the handwritten medical bill from Dr. Milton E. Robbins. Upon hearing Fred Vierschning make this admission, Dr. Robbins acknowledged the truth of said admission by making significant motions of his head and by his speech. After the defendant gained these admissions from Fred Vierschning and Dr. Milton E. Robbins, the lifelong omnipotent gangster, the district attorney Frank Gulata, quickly, in frenzied movement and speech, while gesticulating and actually seizing and quelling both the convulsive Edward Robinson and Fred Vierschning, Gulata then ordered all conversation to cease. End quote.
I don't even know what to say. That's my second U.S. quart of water. There are so many times when he just contradicts himself. Like where he says Detective Becker came over and purloined this injury claim and all my escrow money, and Robinson accused me of running a ring, and then at the grand jury hearing had actually pivoted the charges to something different, and he actually had fabricated this evidence that I guess Becker had stolen, that it was fake. Also, possibly Alva Becker's a guy, so I apologize for the art. I don't know. We'll see how it goes, but I still think like a name like Alva, everything I could find says that Alva is a woman. She might just be a very masculine woman, but Francis says he, so I'm not gonna go into it. But he is obviously going toe-to-toe with Edward Robinson Jr. a lot in this story. And he paints him as this very frenetic, short-tempered guy, and he just throws shots at everyone in this case. Detective Becker is this person who purloined things. Also, the fact that they mentioned this ambulance chasing ring over and over again maybe means that it's true, because he never really says anything bad about himself. Whenever he's mentioning bad things about himself, it's usually because other people are saying it about him. So possibly he may have been running this ring, and this is what got him caught. But like nobody really likes him in the lawyer community, allegedly. And he just loops back around to the meeting with Fred Vierschning and just really doesn't like Fred Vierschning. Honestly, I don't either. He's kind of a disgusting guy that I can't really talk about, mainly because I don't have a lot of information on him at the moment. But through observed lived experience, not actually knowing the guy, but talking about the guy with some other people, not a very good guy. But I want to leave that out of this video. This is not a cancel Fred Vierschning video. But to continue with the story, Dec elaborates, saying that obviously grand jury hearing occurred and he requested to be notified but wasn't. He's stated this multiple times. He's got to state it again to this court. He then says blatantly what I've kind of been insinuating this whole time, that Frank Gullotta has a criminal crime ring going on with all these lawyers doing felonious business, and the reason why he's basically everywhere at once is because he's running this ring. That's why he's called an omnipotent gangster a lot. And the one bit of proof that I hang this entire thing on is a quote from this, because it mentions someone called Arthur Lem, who may be a key in all of this, but I can't really find anything else. So this is what I'm basing it on. It's basically one scintilla, unlike Francis E Dec's 0 scintillas of evidence, states, quote, an example of the type of, quote, unbiased citizens, unquote, chosen to serve as Gestapo-like secret original judges of all serious crimes is one so-called, quote-unquote, Arthur Lem, who, like many other grand jurors, depends upon doled-out business and high salaried income from government employment, which income is doled out solely at the approval of the omnipotent gangster, the district attorney. Such people as this newspaper publicize notorious alien Chinese lifelong gangster, smuggler, perjurer, defrauder, and imposter Arthur Lem make up the rosters of all, quote, unbiased and upright citizens, unquote, who constitute the original secret Gestapo-like judges of all serious crimes, namely the grand jury. As an example, this Arthur Lem is a friend of and high-salaried member of the staff of the omnipotent gangster Frank Gullotta, lifelong district attorney in Nassau County, who recently, in dictatorship-like farce, fixed unopposed election and was elected Supreme Court judge. This defendant was deprived of his constitutional rights under Section 250 of the Code of Criminal Procedure by the district attorney not notifying this defendant of the belated secret grand jury hearing as promised by the said district attorney. Therefore, the defendant was denied the constitutional right to challenge the validity of the secret Gestapo-like indictment proceedings of the grand jury, unquote. That is what makes me think, because Dec sees a lot of things that are correct. Him being a lawyer would mean he's somewhat close to the district attorney, especially considering he is a lawyer during this time. But it could also just be another example of classic 1950s racism. He mentions that he's Chinese, and Chinatown is in New York City, but also he's facing discrimination for being Polish, and during this time the Chinese are communist. So if you're going by the Francis E Dec hierarchy, being a gangster and a minority is usually not something in your favor. He probably thinks that he's a proto-computer god puppet. But during this time, everyone knows that none of those secrets have come to light. But, considering this is a retread of the Nassau County one, he reiterates to the Supreme Court about how he tried to dismiss this trial multiple times, he tried to dismiss the indictment. He also then re-brings up Judge Wenzel and Kleinfeld, namely for trying to sneak inserts into complaints and trying to get a dismissal for lack of prosecution for an alleged 2-year gap. But that's just when the Vierschnings uncovered the fact that Francis had scammed them out of $5,000. So I don't think that's on the judges, Francis. I think that's on people discovering you being maybe a shifty lawyer. You're
the kind of
type
lawyer guilty people hire.
And he then spins something that I had kind of forgotten about until he mentions it again, which is Gullotta is giving all of these adjournments so that the people can have their strings pulled. Gullotta can work his omnipotent gangsterism behind the scenes. That's the reason why there's a week-long one. It's not, it was conveniently timed so that we have a week-long one. It was Gullotta planned this. And this was totally by design. Sometimes I wish I had the glory to connect dots on the omnipotent gangster computer god foresight level that Francis E Dec does. He also says, quote, defendant's motion to dismiss the indictment for lack of prosecution was disregarded and even denied even after several months of adjournments by the district attorney. Finally, during November 1958, a month after the said motion, the day after Frank Gulata, the district attorney, and several of his assistant district attorneys were quote-unquote elected court judges. Then, this defendant's trial was commenced on November 5th, 1958, unquote. Which may be another peek into what's actually going on, because that would mean Gulata is part of the court that Francis is then appealing to after he's kind of already set the stage. Actually, hold on, I want to play with this idea for a second. Francis tries to dismiss for lack of prosecution. Gulata works some legal trickery. Once again, not a lawyer. I don't know how you could postpone a trial this long, and I don't know what failure to prosecute means, but it was obviously being prosecuted because Gulata wouldn't have had to delay, or adjourn. He wouldn't have had to do that if he wasn't prosecuting it, so technically it was under prosecution. He then, after he sets up all of this, gets Arthur Nixon and the stenographer, both of whom he's pretty close to oversee the trial, and he and Robinson and Sullivan's judging the trial. He and Robinson and some other guys go up to the Supreme Court, which Francis E Dec is going to appeal to, and if you want to go a more conspiratorial angle, they know he's going to appeal. They've orchestrated that he's going to appeal because they've altered all these trial notes, and when he appeals, they can just make him look insane, and they can deny him saying, oh, we've given you a fair trial, there's no foul play here, we've been operating as is intended. And then they can deny him, even though they have kind of like a personal interest in this case, but not really, because Frank Gulata is not prosecuting this case. It's Arthur Nixon. But also the district attorney is kind of in charge of district attorneys, ? Not really sure. Once again, not a lawyer, but that's my super conspiratorial angle. And then everyone gets, raises for doing such a good job. Arthur Nixon gets a raise, Sullivan gets a raise, stenographer Burchell gets a raise. And, he got promoted to judge along with Robinson, because Robinson also orchestrated this. That's actually such an interesting idea to play with. Francis then actually attempts to use evidence. And by evidence, I mean the things that I love this, because he says, Nat Burchell is just asserting that these things are true without any evidence. And then he immediately turns around and says, oh yeah, my copy of the insurance claim that Elizabeth Vierschning signed, and Rosenheck's receipt for the Allstate Insurance Company, and the one written by Robbins, which I may or may not have commissioned, are all true, just because you can see, the error that's not there, which you would need the error to be there to prove it, right? I'm not crazy. If your story about her actually signing it and she didn't make the error means that she didn't do it? But anyway, he also just really loves to, whenever he addresses Dr. Robinson in any of his appeal briefs, he just says, well-known perjurer and liar, Dr. Milton E. Robbins. But he then reiterates his story, basically says... The other thing that I have written down is that both of the Rosenheck receipt and Elizabeth Vierschning's Milton Robbins receipt rely on him as a key piece of evidence, and apparently Milton keeps no records, and Francis E. Dec's and Allstate's match without the middle initial error. He then also reiterates the story about consulting a lawyer, even though he is one, which he probably should have gone with the guy that he consulted, because, going back to the beginning of the video, he who represents himself in court has a fool for a client and an idiot for a lawyer. And this lawyer allegedly told him that the documents speak louder than words, and you've totally got this. And if you thought that Allstate, being a massive conglomerate of just random insurance companies, would save them from taking shots from Francis E. Dec Esquire, no. He says, quote, all the Allstate Insurance Company records and indictment confirmed the fact that the terms of the settlement contract were fulfilled, and even to this date, even after the statute of limitations frees the Allstate Insurance Company from all liability, the Allstate Insurance Company has never denied the validity or complained of the falseness of Mrs. Vierschning's personally stated injury claim, for which the Allstate Insurance Company paid $400. The larceny of the $400 from Allstate Insurance Company can only be charged against the self-admitted felonious culprit, Mrs. Elizabeth Vierschning, predicated upon her contradictory claims of injuries she testifies to in court. Therefore, there is no basis of charging this crime against the defendant as claimed in the false indictment. Unquote. Basically here he says, Allstate didn't care whether I took $400 from them, why do you guys care so much? It's because Mrs. Vierschning didn't receive her money, Francis. Even after you took your legal fees, she didn't receive $200, and also Allstate's negotiator manager person said that I would have never accepted this if I had known that I was accepting it under false pretenses. Is that not enough for you, Francis? Do you need Allstate specifically to say, we do not accept this, you are wrong? Apparently, Allstate's representative saying, like, I would have never accepted this if I had known all the facts of the case is not enough for Francis. He needs actual Allstate to come down and say, you were wrong, Francis. And since they haven't said it, he's obviously completely innocent and no money's been stolen because they didn't care. Even after the statute of limitations, by the way, statute of limitations, in case for those of you who don't know, is the limit for a crime to be legally prosecutable. Let's say you steal a piece of candy from a store and your statute of limitations for shoplifting is like a year. If you wait a year and nobody prosecutes you for it, you got away scot-free because no one can prosecute you after that point. You saved like $1, I guess. But he also then, to back up his story about the altered trial records, says that he has a record of every single alteration that was made and has filed it, aka this is his massive 300-page alteration, 771 alteration book thing. And he also reiterates how Elizabeth Vierschning signed the insurance claim backing with moments from the trial. He does a lot of these quotes, but in my opinion, they really are not really that damning. It's more just kind of like, yeah, if you squint a bit, you could generally see how that supports your case, I suppose. But none of them are really like, I got you on this. Because all of those I got you on this moments are cut out of the trial, or he's prevented from doing it because Robbins and Vierschning, he was prevented from cross-examining, even though Vierschning's cross-examination was like 150 pages in the actual trial notes. I have no idea how you can cross-examine someone for that amount of time and not get any gotcha moments unless you're just an incompetent oh, wait a second. Anyway, he then begins to throw out more shots, this time at the trial judge, stating, quote, instead of emphasizing the importance of these unquestioned, authentic records of real evidence, both the judge and prosecutor openly, wantonly, continually, repeatedly, frantically, fanatically, and impishly attempted to thwart any and all efforts of the defendant to inspect, examine, read, and have the prosecution's witnesses explain and place in evidence any item of the authentic Allstate Insurance Company file on Mrs. Elizabeth Vierschning's injury claim. The illegal said efforts of judge and prosecutor were concentrated on minimizing the examination, inspection, reading, explanation, and especially the placing in evidence of any item of the said Allstate Insurance Company file on Mrs. Vierschning, which, although the total real evidence upon which the indictment was supposedly based, each item of the said real evidence, the unquestioned authentic Allstate Insurance Company file on Miss Elizabeth Vierschning's injury claim, completely contradicted the false indictment that was created through the Gestapo-like mafia coercion of the gangster district attorney Frank Gulata and his impish staff. Can the prosecution, representing, quote, the people of New York State, unquote, produce even a kangaroo court decision to support such wanton illegal orders by the dishonest judge William Sullivan, unquote? This section of the text is more blatantly misrepresenting what is legal and what isn't, mainly because he's misconstruing the judge like waiting on him and giving him so much lenience as malice, which maybe he's actually onto something, because usually they give you a lot of leeway if they don't want you to appeal. But hey, he calls it a kangaroo court anyway. Also, he says they're not representing the people, they're purely representing their own interests. He also makes the prosecutor out to be like a performer, and the judge and the people watching the trial are just like his audience, and he's trying to play to them with his talk, because he kind of, I don't know how he actually talked, but Francis E Dec like abbreviates a lot of his stuff, and a lot of it is almost nigh incomprehensible, and he makes him sound a little undereducated. Maybe this is Francis E Dec's narcissism kicking in. But also Charles Martino, the insurance adjuster, catches some shots here too, basically saying that Martino also is getting kickbacks for doing this. He says like, Charles, 10% kickback Martino for, you know, participating in the trial, going to bat for Allstate, and, you know, just doing insurance work in general. He gets like a kickback of like 10% of $400, so he gets like $40 for doing this, I guess, which is like $500 in nowadays. Wow, why are they printing 1.5 trillion more dollars? Anyway, He then goes on to bring up Mr. Urso. By the way, no one from any quote-unquote official state source has brought up Mr. Urso. I guarantee that this is just maybe a fabrication of Francis's mind. Maybe he no longer works at all. Well, if he were a real person, he would have been consulted, and he's never been consulted. Like, they even consulted the garbage man, right? You don't consult the garbage man, but not the main guy who handled the insurance claim, because he then says, quote, "The defendant objected to Mr. Martino's hearsay testimony because the negotiations with Mr. Urso and the judge stated, quote, 'You can't talk about that,' unquote." Thereafter, during cross-examination, Mr. Martino admitted that the first time he requisitioned the Mrs. Vierschning claim file was on 9/27/56, which was 3 days after his claimed first telephone call to this defendant. In spite of the imp, lying judge's William Sullivan's harassment, this defendant obtained this important admission from Charles Felonious 10% Kickback Martino, unquote. He then basically says that Martino's like, yeah, I totally didn't negotiate this. You were right the whole time, I guess. But he says it in kind of like a limp way, while kind of just keeping his own dignity. Sounds like he's just kind of fed up with whatever Francis is trying to like finagle him into saying. Also, this is where Francis starts getting kind of disgusting. In my opinion, one of the only times that I will say he does something like totally reprehensible, and I'm not going to read the quotes from the document because it's just personally a little too much and a little too telling about how immersed Francis was in kind of the 50s mindset, because he throws shots at Elizabeth Vierschning, but not that she's like a perjurer or anything like he normally does. He says, you should just stick with your husband. Just suck it up, because you're only going to find ruin and despair from divorcing your husband. Like, regardless, this is going to lead you to ruin. And she's like, I would rather die than live in this marriage any longer. And he's like, well, you should still suck it up. I know what's best for you. He then retells, remember, Elizabeth Vierschning's husband, Fred Vierschning. He retells the encounter in the district attorney's office. He also well poisons Fred Vierschning in this Supreme Court document, even though he's done it already a lot. But he more insinuates that he's also part of this ring and receiving kickbacks from Gulata because he's also helping take Dec down, and it's far better than stealing cars down south. Because then he goes full schizo mode again, and we get another really juicy Francisism that he's writing to the Supreme Court, by the way, where he begins to state, quote, "This defendant's trial was worse than any Gestapo trial in Europe during the Nazi regime, with a total disregard of defendant's constitutional rights to an impartial fair trial. This defendant repeatedly so complained, but defendant's complaints have been fraudulently deleted from the record, and only a few words of the defendant's repeated condemnation of the Gestapo-like farce trial of this defendant remain." Shortly after Mrs. Vierschning completely broke down during cross-examination and admitted her sworn complaints were perjuries, defendant's cross-examination of her was ordered to stop by the FOP judge over defendant's objections, and the judge and prosecution called Nat Burchell to testify. The dishonest, perjurous, lifelong-aged FOP stenographer Nat Burchell stood petrified, mumbling, leaning against the judge's bench, his face red and dripping wet with perspiration, staring aimlessly at his fellow county employees, who were the selected fixed spectators of the trial, while all other citizens were excluded by force of the numerous county court officer attendants in uniform. Nat Burchell, the aged, lifelong district attorney stenographer, stood petrified as if awaiting his fate to end his miserable, perjurous life, when suddenly Assistant District Attorney Harold Spritzer barged into the courtroom and ordered the trial stopped, and under orders from the judge, William Sullivan, stopped the trial and adhered to the comments of Harold Spritzer, who took the stupefied old perjurer Nat Burchell off the witness stand in the midst of his Nat Burchell's testimony and actually assisted Nat Burchell out of the courtroom. Defendant objected vigorously. Harold Spritzer informed the defendant that Nat Burchell had duties with the grand jury, and the grand jury duties of Nat Burchell were much more important than Nat Burchell wasting time at the defendant's trial testifying as a witness. For anyone but a quote-unquote dumb Polak, as defendant was called by the hand-picked fanatic Detective Becker, the trial would have been ended immediately, and the gangsterous, Gestapo-like, sadistic, decade-long persecution of this defendant
would be investigated, especially if such persecution was inflicted by any other lawyer. Instead, in complete kangaroo court manner, the defendant's trial was then interrupted with not one, but two important witnesses in the middle of cross-examination, namely Mrs. Vierschning and Nat Burchell. The trial was adjourned for approximately a week, from November 6th to November 12th, without notice to the defendant, and in spite of the defendant's vigorous, repeated objections, calling for a mistrial. During this illegal, week-long interrupting pause in the middle of this defendant's trial, Judge Philip Kleinfeld of the Appellate Division of the Supreme Court for the Second Judicial Department repeatedly forwarded messages to this defendant, warning this defendant that the defendant had to capitulate. During a court session of the Appellate Division of the Supreme Court for the Second Judicial Department on Friday, November 7th, Judge Philip Kleinfeld did interrupt the said court session in the presence of the other judges and a court attendant, Vincent Gibitozzi, in order that he, Judge Philip Kleinfeld, stressed that even though this defendant was a practicing lawyer, this defendant must give up his constitutional rights of defending his innocence, and the defendant must discontinue trying his own case and retain the lawyer, quote-unquote, chosen to capitulate for the defendant. As in the spring of 1958, shortly after this defendant was indicted, and Judge Philip Kleinfeld and Judge Harley Wenzel, both of the Appellate Division of the Supreme Court for the Second Judicial Department, caused this defendant to give Judge Philip Kleinfeld and Judge Henry Wenzel a typewritten statement as to defendant's defense to the false indictment. Judge Philip Kleinfeld was once again respectfully notified that this defendant did not need a lawyer to capitulate to the false indictment, but the defendant desired to be given a fair trial to prove his innocence and to provide the over decade-long Gestapo-like illegal persecution of this defendant by Nassau County jurists and other Nassau County officials. After hearing this often repeated request on the defendant's behalf, Judge Philip Kleinfeld, in a message to the defendant, finally stated that regardless of the defendant's innocence, the defendant had created ill feelings amongst the important Nassau County jurists, and therefore the defendant's innocence did not matter. The defendant must give up trying his own case and accept retaining the lawyer, quote-unquote, chosen to capitulate for the defendant without a fee, because Judge Philip Kleinfeld then stated, the judge and jury are fixed, unquote. Therefore, regardless of a defendant's innocence, this defendant would be convicted and given a, quote-unquote, terrible prison sentence. In order to make certain the defendant receive his complete message, Judge Philip Kleinfeld hand-wrote a note to this defendant, outlining the arranged appointment with the quote-unquote Honorable Edward Neary, a former district attorney of Nassau County, the lawyer quote-unquote chosen to capitulate this defendant, and arranged the date and time of the appointment was Monday, November 10th, 1958, 2:30 p.m., which is stated on the note. Defendant did not surrender to the coercive efforts of Judge Philip Kleinfeld. The farce kangaroo court trial of defendant with quote-unquote fixed judge and jury and fixed selected county employee quote-unquote spectators with roving sneering assistant district attorneys seated near the trial judge's bench was more than sufficient to make the defendant cognizant of his status as the innocent quote-unquote dumb Pollock scapegoat made to be an example of, in order to atone for his hundreds of established gangsterous, felonious, ambulance-chasing, fraudulent injury claim lawyers who are secretly reprimanded without criminal prosecution through the near-farce activities of the Arkwright Committee investigating felonious lawyers. The imp Judge William Sullivan did not in the least doubt that Fred Vierschning was breaking down in his perjurous story against the defendant. The imp lying Judge William Sullivan interrupted the breaking down confessing perjurous Fred, the car thief Vierschning, and not only prevented Fred Vierschning from breaking down and admitting his felonious actions of going to Dr. Milton E. Robbins' office and obtaining and paying for Dr. Milton E. Robbins' handwritten medical bill for his wife's injury treatments in order that the defendant could process her injury claim. As Fred Vierschning admitted in the district attorney's office in July 1957 during the non-existent grand jury hearing. In addition, the lying, fancy feather haircut holdover judge William Sullivan, a self-admitted neurotic psychotic in open court, in further kangaroo court style, ordered the faltering, breaking down perjurer Fred car thief Vierschning to answer for his own Judge William Sullivan's, leading questions with a one-word answer only in order to prevent Fred Vierschning from explaining how he, Fred Vierschning, did go to Dr. Milton E. Robbins' office and did pay for and obtain his wife's handwritten medical bill from Dr. Milton E. Robbins, which said medical bill Mrs. Vierschning relied upon to state her doctor-treated injuries to the Allstate Insurance Company, Dr. Rosenack, on May 24th, 1956, which injuries are identical to the medical bill injuries claimed by the defendant as false, unquote.
This is actually super illuminating. I have to go get water, actually. Hold on. Okay. Despite how Francis delivered it, I want to give the state the benefit of the doubt. Mainly because if I had to interpret this through a non-Francis E Dec lens, this kind of sounds like he's harassing Vierschning, Burchell, and Fred Vierschning so much that he's basically getting them to break down. He's effectively eroding them so much because, you know, he's got this view of himself that is so strong and immutable that he couldn't be wrong. But he's grinding all these other people to powder in the court, and it's almost meant to, like, prove that when the assistant district attorney, Harold Spritzer, comes in, and he's, like, assisting Nat Burchell, this elderly guy, out of the room, that it's supposed to be proof of this conspiracy, and that he has to help this guy out of the room because he's needs to work on this grand jury business, and it's so much more important than my trial, which is the complete center of the universe right now. And even if you take, like, the dumb Pollock comment, it's probably Detective Becker saying, like, yeah, because what this reads to me as is the wind up to this, you know, when he says, I have to capitulate, it sounds like they're trying to offer him a plea deal, because this probably just started as, hey, just give her the money and we can forget about it. That's probably what it started as. Because they go through all of these, like, nice accommodations. Like, they specifically, you know, hand him this note that makes sure he's gonna make it. They give him a judge with, like, well, not even, like, they make sure that, you know, he's well informed of when he can make this plea deal. They're giving him an assistant district attorney because they probably know that he's not on the best terms with the other district attorneys. I mean, even if you take, like, the judge and jury are fixed, even if you take those as, like, legitimate, it's probably because they gave him every chance that they could and then they just threw the book at him. Because I assume they just said, Francis, you're probably going to be best off if you just take the plea deal and forget that this ever happened. You'll probably have to pay some money. You won't have to be disbarred. You know, just give her the money back. But, like, if you do try and fight this, Francis, odds are not on your side. And he says, well, this is rigged. I want my day in court. And then they say, okay. And then they throw the book at him. Because all of these don't really... This is where it gets back to being sad again. Because this doesn't really read like someone who's being conspired against. Like, if you read between the lines, it's more of... They're trying to be nice to him, finding out they can't reason with him, and then bludgeoning him with the full force of the law. And even during his trial, he's, you know, like, remember how long Elizabeth Vierschning's interrogation was? AKA, like, 150 something pages of him just interrogating her? You know how long that is? That is, like, multiple days of interrogation. And he's like, I didn't get to finish my cross-examination. I don't think I'd want to see him finish the cross-examination. If we let him just keep going on, I guarantee the court records would have been at least 2,000 pages long. But getting back to the Supreme Court appeal, he then says that Nassau County in New York State have basically sanctioned these farce trials, saying that, I know my appeal to the state isn't going to mean much because I know I'm sending them to the judges who basically put me there in the first place when they were district attorneys. And he then circles back to the 9 questions that he seeks to set judicial precedent with, because to appeal to the Supreme Court, you need questions that are questionably not on the books. And I'm going to read the short ones again, but I'm going to paraphrase the longer ones because I already read them before. I hope you've been retaining them in your head. I know there's a lot to retain here, but I'm going to go over them again. Number 1. May a state consistent with the due process of law guaranteed by the Fourth Amendment, to which guarantee is pertinent the right to a speedy trial, repeatedly adjourn a citizen's criminal trial over a period of 9 months in spite of a citizen's duly undertaken repeated demands for a speedy trial as guaranteed by the Constitution. Francis responds with, quote, This citizen's trial has not only been delayed by the district attorney, but even worse, the district attorney repeatedly adjourned the citizen's trial date several times, month after month, during a period of 9 months, end quote. He also says that the right to speedy trial has been denied due to these adjournments and delays. You know, your adjournments are causing confusion and delay.
You have caused confusion and delay.
Man, I missed that show. Anyway, he also says the DA's given me no cause as to these adjournments, and all of my sworn promises to get into those grand jury hearings were ignored, and he also cites a lot of precedent, which I don't want to get into. This isn't a legal video. This is mainly just a legal typed video. Joke's on you, I only got you like 2 hours and 30 minutes in that it's not a full legal video. It's a legal themed video for Francis E Dec. Joke's on you, I got you. Now, due to the stunk cost fallacy, you have to stay. His second question, basically saying, are you allowed to alter the trial record even when I have an impeccable public record? You know, are they allowed to convict by producing a substantially fraudulently altered official trial record to a volunteer veteran of World War II and a member of the New York State Bar? He says yes to all these questions in case I forget to say it. And he says, despite outlining my reasons for an appeal, and I did my due diligence, I submitted my request. They're supposed to get it to me within 12 days, but instead they got me the trial summary a month and a half later. He then says, oh, they rejected my 794 proposed amendments on 320 typewritten pages. He also says that most of the record is abbreviated or summarized anyway. I mean, I wondered what he'd say about my notes. It's certainly not 320 typewritten pages, I tell you that. He then also says, quote, appeals. The said court sanctioned the wanton, fraudulent alteration of this citizen's trial record by and under the highest of state court jurists. The obviously wantonly, fraudulently deleted, abbreviated, juxtapositioned, hashed together, jumbled and lengthened with substitute material, lengthy trial record was stressed by the citizen as depriving the citizen from appellate review. But the Court of Appeals of New York sanctioned this impish deprivation of the citizen's constitutional rights, and the citizen still remains convicted through the wanton frauds of the New York judiciary, as this citizen warned in his Court of Appeals of New York appeal brief, namely that the Constitution and laws of this country resolve into a facade for a dynamic, labyrinthine, omnipotent, lawless judicial dictatorship. End quote. That, I feel, is another echo of the computer god's influence. But also, he mentioned his Court of Appeals New York brief. I don't know if that was written before this one, but I know Actually, now I'm wondering if I got the order wrong. I'm just gonna go with the order that I had before. I think he wrote to the state of New York, Nassau County Court appeal first. Then he probably wrote this, and then realized that he had to do an in-betweener, and then wrote the second appellate New York State Supreme Court appeal. Number 3 basically says, am I allowed to be cut off while cross-examining Nathan Burchell, Elizabeth Virschning, and be coerced by Judge Philip Kleinfeld to possibly just take a plea deal and get this all over with through possibly intimidatory means, aka the judge and jury are fixed, you remember that? He then also repeats, just flat out, word for word, the impish Judge William Sullivan. Like, you remember that giant schizophrenic quote that I read from the second piece of Zero's highlights of a terrible prison sentence? He just repeats that again, word for word. It threw me off so bad. I'm like, do I actually have to read this again? No, I'm not going to read it again. But I will read you a quote from this section, namely, quote, the warning by Judge Philip Kleinfeld, namely, the judge and jury are fixed, and the citizen's trial would only lead to a terrible prison sentence, quote unquote, was fulfilled, and the citation received 3 felonious suspended execution sentences of 2.5 to 5 years in prison at hard labor. This citizen's persecution through criminal prosecution is obvious when considered and compared to the usual anonymous and semi-secret civil disbarment or simply a short suspension or token censure imposed upon lifelong felonious lawyers, as often exemplified in the 2nd Judicial Department and especially by the many investigations of the Arkwright Judicial Investigative Committee, unquote. This is also super revealing, mainly because it shows that Arkwright wasn't really if what he says is true, Arkwright wasn't really very intensive about getting people removed or disbarred. It's a criticism. Basically, the Arkwright committee would just issue slaps on the wrist for longtime felonious lawyers, but he's basically saying, they're throwing the book at me. And if you take the kind of story that I'm getting where he was offered an appeal but kind of refused it for a day in court and was just a massive nuisance the entire time because he was a lawyer, I kind of understand why they threw the book at him, mainly because they just wanted to be rid of him. And he wasn't well liked. It was already kind of established he wasn't well liked. And he talks about a court case called People v. Coldney. I'm not going to go into it very much, but it's kind of relevant because he's leaning on his good character for the majority of this section. And in People v. Coldney, Francis describes it as, quote, "Said court completely dispensed with the prison sentence received by our man Coldney upon his token plea of guilty for his many-year-long legal career as a felonious lawyer, which amounted to, quote, a series of felonious transgressions," unquote. This is effectively him just asking for the same treatment as our man Coldney, basically saying, why can't you let me off with, the slap on the wrist where I have good behavior? I'm a pillar of the community. Why does nobody like me? I'm making all these righteous complaints that no one's seeing. Maybe he's going against the grain and calling out people who are corrupt, but also he may just be an unlikable person, or both could be true. He's doing it in a way that no one can get behind him on. Question number 4 is, are the prosecution and trial court, the judge, allowed to work in collusion with each other? Francis says yes, and then talks about all the accusations that Robinson made in the grand jury hearing that he wasn't in, and how the minutes have been altered to fix out all these ratings. And he's really showing his true abilities as a lawyer because he's making statements equivalent to Dale Brooks's "I call the state of Wisconsin to the stand." He kind of did it earlier when he's like, oh, they so-called represent the people of New York. But he also just talks about Robbins in general and how none of his perjurous statements are on the record or could be examined. And he once again cites more legal precedent as to why this is wrong, because just forging documents is wrong. Maybe you should have taken notes, Francis. I'm losing it. It's almost, I've recorded more than 4 or 5 hours of raw footage. I'm almost down to my 3rd quart of water, too. Oh, I'm almost done. I'm not even almost done. Number 5, can a stenographer alter notes and write in his own secret code that I'm not allowed to see by depriving me of due process and violating my 14th Amendment rights? Francis said that they did. They deprived him of due process, and he mainly cites how the stenographic notes go into nitpicky detail about you treat it as a confession when it's written down, but when it's said out loud, it's not, or you're trying to make it seem like this is a confession, but it's not, because it's the same thing the state said, because he said some incriminating things, and he's like, oh, this is a confession, because that's the one magic word that he knows, and it can't just be that all of the quotes that he's been citing out of context couldn't be done the same for him. Like, oh yeah, I'm citing all these people out of context. I could totally do that. And then when people cite him in context, it's even worse. He also says, quote, defendant is entitled, quote, to whatever benefit such statement affords, unquote. None of these doctrines were changed. Instead, the court and the prosecutor stated and implied that said notes were a confession or admission of guilt by the citizen. The law, capitalized, prohibits such a construction of statements, citing precedent, or testimony, citing precedent once again, intended and definitely showing the opposite, unquote. Effectively saying, hey, the law's not changed, why are you treating me differently than these guys, even though the context of their cases is completely different. Number 6, are you allowed to deprive me from seeing the stenographer's notes? He says yes, and he repeatedly objected to see the notes, and against this thing called public policy, whatever that means, going against it. Seeing the stenographer's notes would be against public policy, whatever that means. Obviously, he doesn't care. And he says that there were 2 copies, and now introducing another thing way far into the brief, where he says one was altered by Frank Gulata and one was the actual one, and he's been requesting the actual one this whole time. It's kind of like the sovereign citizen. I have 2 bank accounts. All you need to do, I don't have to pay taxes, just take it out of my $1 million. And he also just throws in that this is a violation of his due process. Remember number 7, that gracefully short one? May a state consistent with the right to equal protection, 14th Amendment, procure a felonious criminal conviction against a citizen through the fraud and collusion of the trial court and conspiracy with the prosecution. Francis said that the state procured a victory through fraud and conspiracy, and says, even more artfully, quote,
This citizen still stresses the fact that the said wanton fraudulent alteration of this citizen's trial minutes not only deprived this citizen of any semblance of due process and equal protection and statutory rights to an appeal of his conviction, but also even the fraudulently altered trial record substantiates this citizen's contentions with this citizen's trial was a Gestapo-like farce trial with a dishonest fixed judge, William J. Sullivan, and a fixed jury, which convicted this citizen of the false 4-count indictment in order to create a dumb, innocent scapegoat out of this citizen as an example to atone for all unprosecuted, notorious, felonious lawyers. This citizen's lower court appeal briefs were repelled with different excerpts from the fraudulently altered trial minutes, which would create an unwavering acquiescence to this said contention, even if the most prejudiced person's mind, especially when such wanton persecution is considered from a personal aspect. End quote. He then also just reiterates the story he gave to the lower courts, and I'm asking myself my own question, is it even possible that Rosenhex and Robbins aligned just because he did this after the Allstate exam? Because, oh wait, I know what I meant by that. Because he might have gone and gotten Rosenhex analysis and then said, like, I need a copy of this in your writing. Huh. He also then takes the Gigabrain schizo move, where he says, everyone actually just backs up my story. Even the prosecution's witnesses and what the prosecution says back up my story. If what he was saying was backed up by actual evidence, might have actually been, a gotcha, but considering he's just saying because I said so, and the state is actually dismantling him with evidence they've had for a long, long time, it means almost absolutely nothing. I mean, actually, what universe is he living in? Oh my god. It's a longer quote, but it's relating to this question and it sums it up quite nicely. So I'm going to read it in full. Quote, this citizen, as a practicing lawyer, had become aware of the sacrosanct right of the judiciary to fraudulently alter trial records to the desires of the judiciary. In order to thwart the complete fraudulent alteration of this citizen's trial record, this citizen purposefully testified at length and repeatedly during his trial. The extant remaining fraudulently altered trial minutes are 991 pages long. Inadvertently, a few of the impish derogatory statements by the trial judge against the citizen are left in the extant trial minutes. Part of one such derogatory statement of the trial judge is found on pages 159 through 160. After this citizen complained of the trial judge's lengthy character testimony for the district attorney's stenographer and the district attorney's fraudulently altered stenographic notes, during which character testimony the trial judge attempted to coerce the citizen into allowing the fraudulently altered stenographic notes, during which character testimony the trial judge attempted to coerce the fraudulently altered district attorney's stenographer's stenographic notes into evidence without the citizen examining them, the trial judge ordered the citizen to discontinue his objections to the trial judge's prearranged false character testimony. This citizen objected and stated, quote, under our law, I am forced to proceed when your honor denies me the right to object, unquote. The court then stated, quote, the court feels that everyone here is well advised of what we are contending with, proceeding from that point, unquote. Laconically, in the extant trial minutes, the dishonest imp-fop holdover judge, William J. Sullivan, wantonly reiterated the coercive warning of Judge Philip Kleinfeld of the Appellate Division of the Supreme Court for the Second Judicial Department, namely that, quote, the judge and jury are fixed, and this citizen's trial would lead to, quote, a terrible prison sentence, unquote. The chief henchman to this citizen's persecution, through a legal prosecution, such as Frank Gulata, Edward Robinson Jr., presently both automatically elected Supreme Court judges, and Manuel Levine, District Attorney of Nassau County, are above the law they so wantonly create and administer. The falseness of this citizen's indictment and the prosecution's witnesses' perjurous testimony are not only known to these men and other important members of the judiciary, but in addition, the said perjuries and frauds were fanatically created by and for these men. For me to now overlook these wantonly impish, lawless actions of these men would not only be undermining my appeal rights, but would be much more important. It would be a tacit resignation to the perpetuation of such wanton, lawless actions by the judiciary. End quote. This is an extremely illuminating quote.
Mainly because we get to see his style as a lawyer. We get to see him basically say, my hands are tied, I guess I have to continue, even though you're going to enter these notes into evidence, whether you want to or not. And the judge basically says, everyone knows what's going to happen. Not in the sense of everything's rigged, but in the sense of you're a terrible lawyer and you're not making your case for yourself. And this is, like, while he's interrogating Mrs. Virschning, he also says that he's not giving up. It would be a tacit resignation to the perpetuation of such wanton lawless actions by the judiciary. I don't want to give up. That's effectively what he's saying. I'm not going to lay down and take it. Anyway, on to question 8. May a state ignore the explicit statutory protection afforded by criminal procedure of New York state law? Basically saying it took way too long to get me my appeal brief. He says, yes, they totally did and are allowed to do this, according to the state's angle, and writes once again that the stenographers altered the trial minutes and that it was Frank Gullotta's fault. Wow, if I had a nickel, I could quit my job for every time I had to say that. Anyway, he cries that he's penalized for defending himself, saying, quote, the citizens stressed the omnipotent above-the-law position of any district attorney's office, and also stressed that once the trial minutes were fraudulently altered by the said district attorney's office, then there would be no redress for the citizen because of the omnipotent above-the-law position of the district attorney, end quote. Basically saying, you know, if the district attorney's allowed to alter anything, why even try? It's all rigged anyway. If I'm going to succumb, it should at least be in a fair way. Remember, did he get a fair trial? Did he? How does the computer god play in all this? What's his angle? I feel like you may be coming to some concrete answers. But just wait, we're almost done. Question 9. This one I'm going to read in full and go into the end, because he's going to finish up this Supreme Court appeal brief, and I think it would be wrong to rob him of his words. So I will read this in full, quote, 9. The state of New York did deprive this citizen of equal protection and due process of the law guaranteed by the 14th Amendment by repeatedly coercing the citizen lawyer to surrender his constitutional rights to defend himself by coercive statements and warnings of the New York State judges and court officials, to the extent that the state's Court of Appeals, court clerk under orders of the justices of said Court of Appeals, did in detail letters, wantonly with prejudice, prejudge the criminal appeal taken by this citizen pro se, and the said clerk of the Court of Appeals impliedly completely approved and sanctioned the wantonly, fraudulently altered, almost unintelligible official court record of this citizen's kangaroo court farce trial produced by the lower courts in collusive conspiracy with the district attorney's office, which said frauds this citizen repeatedly complained of in his appeal briefs. The district attorney's office and trial court's many repeated efforts to coerce this citizen into surrendering his constitutional rights to defend himself are stated in detail in other portions of this application. Also included in the other portions of this application are the coercive efforts by Judge Philip Kleinfeld of the Appellate Division of the Supreme Court for the 2nd Judicial Department, who personally made arrangements for an ex-Nassau County District Attorney, namely Edward Neary, to be the quote-unquote chosen lawyer the citizen had to retain in order to capitulate to the false charges of the indictment against this citizen. Upon appeal, and especially in the Court of Appeals, the coercion of this citizen to cause him to surrender his constitutional rights to defend himself once again became open and wantonly notorious. The clerk of the Court of Appeals, in letters to the citizen, wantonly, with prejudice, prejudged this citizen's appeal to the Court of Appeals, making obvious the farce appellate review the Court of Appeals gave this citizen's appeal. Quote, if you desire the assignment of counsel, you need only write a letter to this office requesting that relief. No services required, but this should be done immediately, unquote. Reproductions of the 2 letters from the clerk of the Court of Appeals follow, which letters not only warn the citizen not to undertake his own appeal, but also the clerk wantonly, with prejudice, prejudged the citizen's appeal and impliedly stated the Court of Appeals' approval of the wantonly, fraudulently altered, and almost unintelligible official record of the citizen's trial as produced by the courts in collusion with the district attorney's office. Conclusion, the judgment of conviction should be reversed and the indictment dismissed. Dated September 21st, 1961, Hempstead, New York. Francis E Dec, appellant pro se. Unquote. What does all this mean? If you read between the lines, people are being super nice to him. Especially that if you desire the assignment of counsel, you need only write a letter requesting the relief. No services required, but should be done immediately. They're basically saying,
hey, we know you have no money. If you want a public defender, we will get you a public defender. Just do not represent yourself because you're going to basically crash and burn like Will Rogers when he tried to oppose FDR. I mean, they're being super nice to him if you're reading in between the lines, but he's just like, this is a hostile action, the world is against me. It's like the Artaud syndrome, but he's not going out like punching random people in the face. He's just accusing everyone of being a communist gangster, liar, perjurer. But there's still one more document, mainly that I want to read in full. Because this petition for rehearing is, I don't want to say indicative, but it's the last thing that he would ever write to the Supreme Court. And possibly upon getting this rejected was his, how do you say, canon event. His petition for rehearing is not as long as all the other ones. I'll put a timestamp if you want to skip it, but I should advise that you don't. Mainly just because it's the end of the road. If you've made it this far, you've obviously sat through a lot of ranting and raving by this man. You can at least do him the effort of seeing through his funeral dirge. As I read, petition for rehearing, quote, below is a true copy of the second paragraph, lines 13 to 25, the end of the page, on page 31 of the psychotically, sadistically, wantonly, fraudulently altered official Nassau County Court. New York State trial record of this petitioner's Gestapo-like farce trial, quote-unquote, people of the state of New York versus Francis E Dec. Quoting the paragraph says, quote, and I say that Mr. and Mrs. Vierschning knew that the monies was there and are being used as dupes because they are fearful either they prosecute me or they bring it forth, the insurance company, to show Mrs. Vierschning you were hurt, so and so and so and so, and retain the lawyer. He has a retainer. You committed fraud, and your husband automatically is guilty of an attempt of committing a fraud on the insurance company, and the lawyer has done his work according to the routine, which the district attorney has 50% of the fee is mine, $200, which they agreed to. But if the client knows nothing of it, unquoting the second paragraph. Below is a true copy of the third paragraph, lines 11 to 19 on page 845 of the psychotically, sadistically, wantonly, fraudulently altered official Nassau County Court New York State trial record of this petitioner's Gestapo-like farce trial, quote-unquote, people of the state of New York versus Francis E Dec, quoting the third paragraph, quote, the conversation in these records, they claim, that were not made is not such that I would have nor anyone would have where direct questions in reference to a crime. I have never acknowledged these. They were admitted in evidence over my objection, that they were hearsay, as not in accordance with the best evidence rule, as not in accordance with material and essential items. To the court and other objections, I have not adopted them. Ending, quoting the third paragraph. In the Supreme Court of the United States, petition for rehearing of petition of writ for certiorari in forma pauperis, number 558 miscellaneous October term 1961, after order of denial, same on January 15th, 1962, wherein respondent ignored this court, namely no response of any nature was filed in opposition by the respondent to the said petition for writ of certiorari. People of the state of New York, respondent versus Francis E Dec petitioner, Francis E Dec petitioner pro se. Please take notice that upon this petition for rehearing of the petition for writ of certiorari in forma pauperis, number 558 miscellaneous October 1961, term denied on January 15, 1962, and upon all other papers in this matter, this petitioner makes this petition for rehearing of the said petition for writ of certiorari in good faith and not for delay, and that the intervening circumstances are of substantial and controlling effect, that this petition is restricted to above the specified grounds. This petition for rehearing after said denial of the petition for certiorari is not an empty formality, and denial of certiorari should not be prejudicially treated as a definitive determination, subject to all the circumstances of such an interpretation. Actually, the absolute contrary status exists under such conditions. Therefore, now this petitioner makes appropriate showing that substantial matters are presented on rehearing, and at least the formality of the appropriate opportunity should be given for doing so. Francis E Dec is the above-named petitioner of this petition for rehearing. The petition for certiorari denied, wherein no response of any nature was filed in opposition by the respondent. The petitioner has attached to this petition and incorporated in this petition 2 excerpts from the wantonly, fraudulently altered official New York State version of this petitioner's trial minutes as produced by the Nassau County Court, produced by Michael Wauch, the official court reporter of this petitioner's Gestapo-like farce trial. Said excerpts are the second paragraph of page 31 and the second paragraph of page 845 of the said fraudulent trial record. This petitioner has selected these two excerpts of the psychotically and sadistically wanton fraudulently altered official Nassau County Court, New York State version of the trial minutes of petitioner's Gestapo-like farce trial in order to produce unimpeachable evidence that said official Nassau County Court, New York State trial minutes of petitioner's farce Gestapo-like trial as produced by Michael Walk, the official Nassau County Court reporter, have been psychotically, sadistically, and wantonly, feloniously hashed together, juxtapositioned, deleted, abbreviated, and lengthened with substitute material by Michael Walk under the behest of a lawless, deranged, sadistic, wanton, omnipotent Gestapo gangster, Manuel Levine, District Attorney of Nassau County, New York. The 991 pages of the said fraudulently altered official New York State record of petitioner's trial minutes is so wantonly fraudulently altered through hashing together, juxtapositioning, deletion, abbreviation, and lengthening with substitute material that any attempt to read such wantonly, fraudulently altered official Nassau County Court, New York State trial record produces an unintelligible, extremely confused rigmarole of senseless words. Out of the quote, that might be a little too revealing, Francis. But anyway, back to the quote. As officially stated by the clerk of this court, quote, the respondent made no response of any nature and made no opposition to this petitioner's petition for certiorari, end quote. Therefore, even disregarding the absolutely unprecedented, innumerable multitude of detailed questions presented, this court, in the petitioner's 101-page petition for certiorari, this court actually had only the said wantonly, fraudulently altered official Nassau County Court, New York State trial record to substantiate any judgment in order of denial of the said petition by this court. Therefore, the all-important decisive status brought about due to the intervening circumstances that, quote, the respondent made no response of any nature and made no opposition, unquote, is that the only basis for this court's withdrawal from this matter through this court's denial order is based upon the 991 psychotically and sadistically, wantonly, fraudulently hashed together, juxtaposition, deleted, abbreviated, and lengthened with substitute material official Nassau County Court, New York State trial record of this petitioner's farce Gestapo-like trial. Any attempt to read the said psychotically, sadistically, wantonly, fraudulently altered official Nassau County, New York State trial record of this petitioner's false Gestapo-like trial provides an unintelligible, extremely confused rigmarole of senseless words, which is the total basis for this court's denial order of this petitioner's petition for certiorari. Therefore, now, this petitioner makes more than appropriate showing that grave and substantial matters are presented on this petition for rehearing. The petition of certiorari and petitions that this court not withdraw from this matter, but instead grant the said petition for certiorari. Dated February 5th, 1962, Hempstead, New York. Francis E Dec, petitioner pro se. End quote. If you're wondering if I repeated any part of that, no, he just repeats a lot of the terms, especially that one paragraph at the end where he says it's just reduced to a bunch of senseless words when he said that like 5 seconds ago. That's true, but I'm going to say getting this rejected is what drove him insane. Because he gives you no evidence, there's no hard evidence, not citing anything, not saying, oh, all this stuff. He's doing what he accuses other people of doing. He's saying, you're just taking this at this guy's word that he's saying that he's honest, and he expects you to do the same thing. He's projecting. But I don't think writing this is what drove him insane. I think it's getting the Supreme Court to deny him his appeal and realizing that he would be disbarred, he would be victim to this massive conspiracy, and everything would fall against him, is probably what inspired most of his writing. I mean, think about it. Conspiracies that you can't fight against. Well, hold on, I'm jumping ahead of myself. Let's go back to those 3 questions I posed to you almost 3 hours ago, I suppose. If you're watching this in one part, I'll try and cut it up into little pieces so you can listen to it like an audiobook, I suppose, but oh boy. Anyway, question 1. What's Francis's angle? Personally, I would say it's preservation of his status as a lawyer and a somewhat justice angle. Because he says, I've been complaining for decades about how these people have mistreated me, and all of this is done because I don't want to capitulate to a corrupt system. If we were saying that about like a fiction novel, you'd be completely for this guy. You'd be saying, yeah, fight the power. You gotta show people what you're about. He's making all these complaints, no one's listening to him. And He's representing himself to preserve the fact that he is a lawyer. He's saying, like, my profession isn't worthless. I don't have to hire someone that I can already, for a job that I can already do. And I feel that that pride is what leads him to the fall. That pride of being a lawyer. Why pay someone for something when I can just do it myself? Sometimes you need to accept the assistance of others, especially when you're facing disbarment from the career that you're trying to preserve. But I suppose, on the other hand, he did go out on his own terms. Not in any more serious sense, more in the sense of he got disbarred under his own powers as a lawyer, so I guess he wasn't good enough to be on the bar by his own standards anyway. But it's kind of sad. Mainly because we get into the second question. Where does the computer god play into all of this? Now, if you don't know the history of Francis E Dec, first of all, shame on you, and why are you listening to the entirety of this video? Second of all, thank you for staying, and let me explain. So, the computer god's conspiracy is one that you can't fight against. Everyone is implanted from birth by these people in high positions of power with Frankenstein controls. These Frankenstein controls feed you propaganda, alter your body through these sadistic experiments in the computer god's sealed robot operating cabinet. Aging doesn't exist. The computer god just molds you to its will. It can manipulate history. Anything can be whatever you want it to be, if you're the computer god at least. And just seeing over and over again, he says, this was manipulated. The district attorney's against me. The judge is rigged. Like, all the district attorneys are against me anyway. This detective stole all my evidence. They prevented me from interrogating this guy. He's not viewing it through the angle that a person or a lawyer would view a case through. He's kind of already descending into the computer god fog, where everything has to be this grand conspiracy that is meant to target solely him. Because in the computer god lore, he has Frankenstein controls as well, but he doesn't have the constant threshold brainwash radio that makes him a slave for the rest of time. It's that ability for him to just assign it all to a conspiracy rather than take blame for one modicum, one scintilla of anything. And the last thing I have to ask you is, was this a fair trial? From all the evidence that I can derive, obviously not having the minutes, obviously not being a lawyer, I would say they gave him the best shot possible. Mainly because they gave him so many opportunities to get out of it. What he interprets as someone trying to get him to capitulate to a higher power is basically just them saying, let's resolve this and get it done with. Like, I've been to county court a handful of times, not for anything important, but, usually they'll just, kick down the fine, or not even give you, like, misdemeanors. Like, oh, you lack proof of insurance at a traffic stop. Well, do you have insurance now? Can you produce proof? Okay, we'll waive it. Oh, good for you. You're free to go. Like, usually, the reason why district attorneys want to convince you into taking the plea deal is because it makes everyone's life easier. The district attorneys don't have to waste time prosecuting people. You don't have to waste time going to court all the time. They're just going to take the money for the state or issue a penalty or whatever and be done with it. Wash their hands of it. Done. But effectively, when they come to Francis E Dec and say, like, hey, you want to take the minor fine, just give her the money back, we'll probably, issue that little slap on the wrist from the Arkwright Committee. Why can't I get that? Probably because you dragged the district attorney, the stenographer, numerous judges, especially William Sullivan, through the ringer, having like a 200-page interrogation of someone who is allegedly brought as a witness, so much that they break down in court along with Nat Burchell. He does this twice, possibly even 3 times if you count the DA's office. He drives Fred Vierschning just because he wants money, because he's probably struggling in New York City. Not everybody's a mobster, gangster, car thief, and plus prostitutes cost a lot. He makes them go through all that rigmarole, all that pressure, all that stress, and basically gives them nothing in return, and tries to appeal it like 7 different times, runs them through the ringer. He's like, here's all my alterations that you should add to the trial record. Why would they do that? They have no reason to do that. They also say, like, Judge William Sullivan is of unlimited patience, right? They don't have a biased judge. They have a judge that wants to prevent him from appealing just so he doesn't have to waste any more of his time. Because, to reiterate, when they're trying to get you on something, they usually say, here's some advice. In the Dale Brooks trial, I always compare Francis E Dec to Dale Brooks, and he's basically the same guy, except he's not a sovereign citizen. He's a schizophrenic conspiracy theorist who thinks that a computer god controls everything. Maybe it does. I don't know. I might have my constant threshold brainwash radio tuned in to the confirmed
conformist propaganda. But it's as fair as it gets. They gave him as much leniency, they gave him advice. At multiple times, you can just pick out that this was ultimately him just stealing the show, and the fact that they even allowed him to cross-reference Elizabeth Vierstein for more than 100 pages should be a testament to how patient these people are, especially when he says these altered notes, which, if we take the state's word as exactly what happened, he says these are rambling and incoherent. That's just you, Francis. That's on you. That's you being rambling and incoherent. That's not the court. Arthur Nixon may have an accent. Becker may just be doing a job as a police detective. I mean, maybe even being a bit of a jerk about it. Because Detective Becker sounds a little shady, a little seedy, I guess, but not in the criminal sense, more in the sense of, they may have a bit of a racist side. The whole dumb Polak comment doesn't come from anywhere. Or maybe it's just, I'm gonna fight this to the very end, and then she's like, oh, you dumb Polak. Why are you even trying? I take the, why are you even trying? They're trying to coerce him from getting out of it. Or saying that everything's fixed. Probably just because he's a terrible lawyer. That's my guess. They're saying he's gonna get his ass handed to him because he's a terrible lawyer. He has no way to defend himself. He's got literally nothing. You know how sometimes in pro games you see people just hit concede and you don't know why? That's what high level play is knowing you can't win. Sometimes chess players will just, shake hands and say, okay, we're done. Or, lantern control in Magic the Gathering. I know that's a super specific reference. It's all about the mental game. They're basically saying you can't win because you have nothing. So know when to give up. And Francis doesn't. I will at least give him that he is very persistent. And the fact that he will go on for 20 more years to live in abject poverty and right to expose a conspiracy greater than any one single man is capable of exposing is a testament to how committed he is. But that is the last major piece of Francis E Dec material. The last big chunk. And it's almost heartbreaking that this journey's coming to an end. But just know there will be some tidbits. There is going to be a tidbit video, mainly fitting in all the associated art or letters or other associated things that I couldn't fit into a dedicated video, and this one's already long enough. I'm looking at the live recording and it's already 5 hours and 12 minutes long. So I don't want to continue on this anymore. I think I've said my piece, and I hope that everyone involved finds theirs, because I could not imagine having to deal with such an arcane profession as law and deal with people like Dale Brooks or Francis E Dec or other people who represent themselves in a completely nonsensical and insane way, and you have to purposefully give them the patience of a saint so that they can't claim it was a mistrial and that you were biased against them. If you made it this far, I sincerely thank you for watching. This video, even now, is taking up way too much of my time. It's October 24th. I have a week to edit and deploy this video, and I don't think it'll be enough. Only you will know if I succeeded. But I want to thank you for watching. I want to use my Frankenstein controls and psychic power to compel you to like, comment, and subscribe. I was waiting until your mental defenses were weakened so I could deploy it on you, just like the good old days. But seriously, if you made it this far, you'll probably like my other stuff. On the end screen, there will be some stuff for you to click on. Try something else. Or if you just made it this far out of spite, I hate you too. But I also think you're annoying. I also should also say some third thing that would indicate that I'm projecting like Francis E Dec. But anyway, I appreciate you making it this far, and I hope you appreciate the amount of effort that I put into this video. By far the longest in my catalog. Stay safe, and don't let the parroting puppet gangster slaves get you down. All that mess. It can't be over. I can't just... all of this legal archives and nothing. I'm just glad no one can tune into my eyesight TV and see me at my weakest moments. I mean, I know there's more. It's just not showing itself to me. Then I don't need to look for a handle or a door. Maybe it's... the computer god is taunting me. Maybe it's in these archives I've just been led along by clues. What's readily available? What if I tried to look in Obscura? Think of everything that I've been taught on this mission, and think about what I'm looking for. What do I want? I want what I know exists. I want the pasteurized milk conspiracy. I want the history of the computer god. I want the 8-page communist computer god expose letter. I want to know everything. Obviously, I'm going to have to compromise, but I'm envisioning it. What does Francis talk about in his writings? Judges. We're in a court of high holy law. What is the ultimate extension of the judge's power in the courtroom? The gavel. If I take this gavel, What am I seeing? Holding this in my hand, thinking about my Frankenstein controls and what they mean. Well, he talks about a lot of... No. I have to think about this in obscura. There's no other way. If I try and manifest something, it will be there. If I clash the gavel down and cry, denied. I did it! I found this! I don't have to wait to be shown the way. I'm so happy. What's in here? I need to see. It seems it's missing the expose letter, but the pasteurized milk conspiracy's here. This is the computer god's secret archives. And not like the visible secret archive. This is the secret we know it existed, but no one could confirm it until now existed archives. Oh, my Frankenstein controls are giving me so many positive feedback notes. I think I know what I have to show to the world. And it starts with what I know best. Pasteurized milk.